Hear ye, hear ye, hear ye. All persons having business before this court, ought to give their attendance and shall be heard.
Thank you. Please be seated. People versus Rush.
May it please the court. My name is Dina Mueller, and I am pro bono counsel for Terry Rush, who is convicted of criminal possession of a forged instrument and identity theft. There are 2 points I would like to make this morning. First, that the closure of the courtroom was utterly improper, and second, that there is insufficient evidence to convict Ms. Rush of either of the crimes. The right to a public trial cannot be denied. It's guaranteed by the U.S. Constitution, the New York Civil Rights Law, and the Judiciary Law. However,
Can there be a trivial, violation, counsel? In other words, the record seems to indicate that there was a period of time where somebody was asked to step out, but they were going to be brought back in as soon as potential jurors were marched into the box, I think the phrase was.
First of all, Your Honor, this court had the opportunity to recognize the triviality exception in the Torres case.
And you didn't care for Judge Scudder's, in my opinion. At least that's what your brief said.
The Court of Appeals did affirm Torres. And
the Court of Appeals, in its affirmance, said that what happened while the person was excluded from the courtroom was not trivial.
That's exactly
so it
correct.
seems to acknowledge that there is, or at least imply that there is, a trivial exception or triviality exception.
If there was a triviality exception, this is not the case to recognize it. Triviality arises in the context, I think the seminal case is Peterson. That case starts with a proper closure where testimony of an undercover police officer was occurring, and so the courtroom had to be cleared. The court inadvertently didn't reopen the court after that testimony, and no one noticed and no one objected. In this case, the closure is improper, and I'll get to that later, but that's, all 4 of the Waller v. Georgia factors were not met in this case. So you have an improper closure, an intentional closure, and it was vigorously objected to by counsel for Ms. Rush. So I think that takes us out of the land of the triviality exception just to begin with. But even those cases that do recognize it or have considered a triviality exception hypothesize.
Let me just interrupt you. The court seemed to make clear to the person who was being excluded that he could, I think it was a he, right? He could re-enter after the first 21 potential jurors were seated in the jury box. So he knew he could come back in, and that's all that happened before he was permitted to come back into the courtroom. So it seems that nothing substantive happened before he was permitted back in the courtroom.
I think there's 2 parts to that, Your Honor. The first is it wasn't a burden upon Mr. Granville, who was the father of Ms. Rush's children, to come back into the courtroom. The court specifically excluded him and told him they would let him know when he can come back in.
Couldn't he have at least waited outside the courtroom? I mean, they went out to get him, he was gone.
I think the record's not clear on where
Is that a burden for him just to simply wait outside the courtroom?
Interestingly, in this case, Your Honor, no one told him how much time. There was no estimate of how much time, and I don't think it's reasonable to make him stand hostage outside the courtroom doors waiting for an indeterminate amount of time.
Counselor, what the court said was after we seat the first 21 jurors, which we're talking 5 minutes, but setting that aside, you seem to be arguing that the closure in and of itself, okay, is what starts the problem. And it appears that, like I said, it appears that in the Court of Appeals Torres case, why would they ever reach triviality if all they had to say, court was closed, end of question, and then therefore affirmance, and didn't. It went on to discuss the triviality. So it seems to me that the court recognizes that you can close it, and in that situation, she was excluded because of the wife or the defendant was excluded because of overcrowding, and this, in a different set of facts though, and in this case, once again, the individual was excluded because of the lack of space in the courtroom.
Well, I think, first of all, Your Honor, the courtroom actually wasn't overcrowded. On the record, there's a finding of fact that the stated capacity of the courtroom was 68 persons. In response, at page 35 of the trial transcripts, the judge says So 56 people, we are getting close to that number. There was room for at least 12 more people in the courtroom, and defense counsel requested that Mr. Granville be allowed to stay, and the court summarily rejected it. Now, I'm kind of getting into the fourth factor of the Waller v. Georgia test, which is specific findings on the record. There are no specific findings that there wasn't room for him, but even if there were, categorically, overcrowding is an insufficient reason to close the courtroom. The first factor of Waller v. Georgia is an overriding interest. And the Court of Appeals in both Martin and Floyd said overcrowding is not a sufficient overriding interest. So it wasn't proper.
Does it then boil down to triviality? Let's assume that there was an error there to close the courtroom. But was the error significant? And didn't the Second Circuit recognize a triviality exception in Gibbons?
The Second Circuit did recognize it in Gibbons, but at the same time in Gupta, it said where it categorically said where the closure lasts for the entirety of voir dire, it is not trivial.
Well, see, that's the distinction, is we're talking about, they're looking at what transpires during the closure. That's what gives rise to the triviality question. That's, to me, what the Second Circuit has said in the Court of Appeals, is what transpired. And as we said earlier, the record reflects during the hearing that all the court did was do a general introduction. And we have nothing in front of us other than that took place. So what you're saying is that the seating of randomly 21 prospective jurors and the statement by the court, the introductory statement, that in and of itself is not trivial.
Exactly, Your Honor. There's two parts to that response. First of all, the entire proceeding is substantive. Everything that goes on from the minute the jurors come into the courtroom.
I know, but remember, the point I'm losing, if it's substantive, then we never get to triviality. So there's got to be a fine line between when it's substantive and when it's trivial.
Well, Your Honor, we really shouldn't ever be getting to triviality because the Court of Appeals held in Martin, and this court quoted in affirming, with the affirmance when it made the Torres decision, that the rule of reversal applies irrespective of prejudice. So it doesn't matter what's happening in the courtroom. If the closure is improper.
Then how do you explain the Court of Appeals statement in Torres that what happened in the courtroom in that case was not trivial? Why say that at all if trivial's irrelevant?
Well, I think in that case, Your Honor, there had been dissent at this court level that suggested that this court should follow the triviality exception, which has been raised in other courts. But again, in much different contexts. In a lot of those contexts, in the Gibbons case, the court hypothesizes, what if the court was closed for several hours of a multi-month-long trial? Would that be trivial? And that's not this case.
Well, in the Torres case, it was a couple of hours. I mean, I was in the dissent, and Judge Perdomo was in the majority, and they articulated in the majority why it wasn't trivial, and I think the Court of Appeals bought it. So it was just more than just live and leave. I think the person may have been gone for 2 hours or maybe longer. I'm not sure in that case, but it was a substantial period of time. This one, it appears, seating of 21 prospective jurors. And you've been in a courtroom before, seating of 20 prospective jurors, 5 minutes, 10 minutes, nothing takes place than just pulling names out of a hat.
Your Honor, I think that, first of all, again, there's the public has an interest to every part of the proceeding, including the seating of the jurors, the initial questioning. It's not clear on this record what was happening in the courtroom while Mr. Granville was excluded, because the deputy who goes out to look for him doesn't know when she went out. She doesn't remember if questioning had began or not.
But the difference here between this case and Torres on that issue is that in Torres, the person was led to believe that they were not permitted to enter until a deputy came out. The witness here was given a different instruction. The witness was clearly told, you may come back in as soon as the 21 jurors are seated. That's different, isn't it?
No, the obligation is always on the court to reopen itself. When the court closes, only an affirmative act reopens the court. We're talking about violating not only the right of Ms. Rush.
Is the deputy walking out to search for the person that's been excluded? Is that an affirmative act?
She did, Your Honor, but I think one thing that's important is she did it on her own accord. At page 24 of the hearing, the post-trial hearing.
As opposed to being directed by the judge?
Exactly.
So the judge did say, though, you can come back in, and the deputy's there, hears that, and then in reaction to that goes out and tries to bring the person back in. Is that not an affirmative direction by the court?
It's not.
As executed by the deputy?
I think that the court has a significant burden to reopen the court. And as the decision held in Torres, until somebody told the wife of Torres, that she could come back in, she was excluded. And the same thing happens here. Even though he wasn't told directly by the court, his counsel was told that we intend to come get him, and nobody came and got him. If I could, I'd like to move on, though, to the second point, which is that there's not sufficient evidence on the record for either criminal possession of a forged instrument or identity theft. Knowledge of a forgery and intent to defraud are both elements of the criminal possession of a forged instrument, and they need to be proved beyond reasonable doubt. Here, the only evidence that goes to intent are these blurry ATM photographs. It was exhibits 13 through 16. First of all, those should never have been admitted. They're Molyneux evidence of an uncharged theft from Mr. Lawhorn's account. And under that standard, they're only admissible if the identity of the person in the photograph is proved by clear and convincing evidence. Here, the photograph is so blurry and it's of such poor quality, you can't even tell the gender of the person who's taking money out of the ATM. So it's not probative as to whether...
It seemed peculiar to me. Didn't the defendant's husband actually recognize his wife in the photograph when it was sitting on an investigator's desk?
Your Honor, I think there was some issue about that, but that certainly was never before the jury, and the prejudice that could have gone to the jurors from seeing this photograph, they could have assumed that the only reason it was presented to them was that it must be her.
Let's assume we get by that issue. Now we're dealing with the Barden problem in our case in the Fourth Department. And obviously you take issue with our decision and want us to follow the First Department's decision.
Certainly the appellant.
If not, you have a problem.
Actually, Your Honor, I don't think we do have to have a problem here. We would certainly suggest that Barden may recognize the distinction between assumes the identity and use of personal information, but even if this court were to affirm use on and say that Ms. Rush's use of Mr. Lawhorn's name automatically assumes the identity, there's a second issue there, and the statute requires that by assuming the identity, you thereby commit or attempt to commit a fourth Class D felony. And in this case, the Class D felony would be the criminal possession of a forged instrument. So first of all, we contend she's not guilty of that. There's no evidence of the intent or the knowledge. But even if she were guilty, that crime was completed long before she ever walked into the bank, before she ever used Mr. Lawhorn's name. The assumption of his identity did not further criminal possession of a forged instrument in any way. So she didn't thereby commit a felony. And in fact, we would submit that what she did was she thereby engaged in a legal banking transaction. The witness for the prosecution from the bank testified that no ID is required to make a deposit into somebody else's account. It's a legal action. Anyone can do it. So what she did was she used his personal information to make a deposit into his account, not to commit a felony. So she cannot complete the criminal identity theft crime because of that.
Counsel, you should wrap up.
Okay. Well, thank you, Your Honor. Just because of the lack of evidence and because of the closure, we submit that Ms. Rush's conviction should be reversed. Thank you.
Good morning. May it please the court, Leah Mervine on behalf of the people of Monroe County. I would just note, with all due respect to Justice Peredato, I do agree with the dissenters in Torres. I believe that the Court of Appeals was very clear that there is a trivial exception when they reach Torres at the Court of Appeals. They cite to Martin. And I think that if there was ever a case for that, it was this.
Well, let me ask you this, counsel, and help me with the record here a little bit. It seemed to be that the court, once the jurors were seated, so this is now the time when the person can come back into the courtroom, the court seemed in the record to kind of flow right into the voir dire, and the deputy then on their own goes out into the hallway. Is there not even if it's brief, is there not a period of time where there's questioning taking place, or at least direction from the court as to what voir dire is, or an explanation, and doesn't that go to substantive voir dire taking place?
Justice Whalen, I think that sort of conflates a few issues here. I think perhaps that could be substantive if the court was giving any instruction to the jurors, and how the record reads is sort of irrelevant to this court's understanding of the case. I think one of the challenges that we have here is there was a 330 motion filed, and obviously this court is familiar with it has to be a decision made on the record. And I think the record in and of itself is not going to ever disclose the timeline here. And I think, I understand the court's rationale for putting on some testimony to buttress the decision-making process that went with the 330 motion, but I really think that if this court were to delve into the timing, and I know Appellate mentions, well, the record's unclear, the record's not so clear here, the record's not clear, that reeks of a 440 motion to me. And at a 440, the burden would be on the defendant to show that her boyfriend was there, was waiting. I know there's a lot of mention in the briefs and reply briefs, well, maybe he was here, maybe he was there. None of that's borne out in the record, and this court can only look to the record. So to sort of sum up that question, it's an issue of perhaps there was some substantive action that was taken at that time, but if you apply the triviality exception that the Court of Appeals appears to have provided, that it would be irrelevant. We're really talking about, and if you've been in the Hall of Justice, I've done jury trials in courtrooms that were the size of my bedroom, where we literally have people standing against the back wall shoulder to shoulder, and until you put 21 people in that box, there literally is no room. I don't know that it's dispositive that the fire code says there can be no more than 68 people. That could be people literally standing one up against each other like a subway car. I don't know that's what we want for a court.
Counsel, I have a more of a pointed question. Counsel seems to be arguing this, and this is an interesting, is that from the majority's decision in Torres, and obviously affirmed by the Court of Appeals, it seems that the burden, the onus is on the court to take an affirmative step to reopen the courtroom.
Correct.
And it appears now she's arguing the fact that the court never articulated or took upon its affirmative obligation, but instead the deputy took it upon themselves to do it. Now, is that how do you justify the distinction there?
I think that goes back to the issue again of what is a record going to reveal and what is the judge's burden on the record. So I don't think that any court, including the Court of Appeals, has explicitly stated the judge, once the courtroom is reopened, must make a showing of this on the record, must make some type of announcement, or that there's something that would trigger announcing that. And in this case, I believe Judge Castro had the deputy testify because he wanted to demonstrate this was done. And I think one of the things that happens in the Hall of Justice is that our judges work very closely with their courtroom deputies. They're often assigned to a specific judge. They work exclusively with that judge, and they are working in tandem essentially with the judge. So I believe that by going out into the hallway and reopening the courtroom, that was, in essence, a proxy for the judge's action, and that's why the judge put that on the record. And I think the court can look to that. And again, if it does go beyond the record, I would ask this court to find that this really is a 440 issue that needs to be flushed out by defendant. And just very briefly, with regards to the substantive matter of the counts, I would ask that the court follow its precedent. I would also note the case of People v. Coney, C-O-N-E-Y, which is at 109 Appellate Division 3rd, 1154, and I believe that Justices Sentra, Scudder, and Presiding Justice Whalen were on that case. I do believe those to be very similar. I do believe that Judge Castro's finding that uttering the instrument was dispositive here, and I would ask the court to affirm.
Thank you, Counsel.
Thank you.
People versus Thibodeau. Justice Joseph is recused.
May it please the court, I'm here today to address a miscarriage of justice that occurred more than 21 years ago when Gary Thibodeau was convicted of a crime he didn't commit. Gary Thibodeau was convicted of kidnapping Heidi Allen, even though there was no eyewitness placing him at the DNW that morning. There was no forensic or physical evidence that connected him or his co-defendant brother to Heidi Allen. The law enforcement had unfettered access to the van that Richard Thibodeau drove that morning, as well as both Richard Thibodeau and Gary Thibodeau's properties. Additionally, both Gary Thibodeau and his co-defendant brother Richard have always maintained their innocence to law enforcement, and the prosecution could do no more than guess at some type of motive. Since then, new evidence has surfaced over the course of the past 20 years, squarely pointing to three new suspects: James Steen, Michael Bohr, Roger Breckenridge. At least one eyewitness has placed James Steen in the parking lot of the DNW attempting to kidnap Heidi Allen that morning. Another eyewitness placed all three men at her residence with the van.
Let's just stop there a second. The eyewitness that identified him in the parking lot was who?
That was William Pierce.
Okay. And subsequently, William, I know, and William Pierce, but didn't he identify Thibodeau first when he drew a beard on him? I mean, it appears from the record there was some conflicting testimony as to he identified one, then he identified the other. And correct me if I'm wrong, because as you know, you lived with this case, and it's a volume. I mean, this case is huge. Wasn't there a point in time where he was shown a photo identification of both Thibodeau and that individual in the same photo array, and he couldn't identify either or?
The key to the testimony with
No,
regard...
the reason I bring that up
Yeah.
to you is because I recognized that it should be taken witness by witness as opposed to, in a vacuum. But that ultimately leaves the court with a credibility determination, is what I guess what I'm getting to.
Well, the court based its determination and its decision on clearly erroneous facts and also a flawed legal analysis. Take William Pierce, for example. In the court's decision, the court indicated that William Pierce can't be believed because he didn't stop to help. Well, the same can be said for the prosecution's witness against Gary Thibodeau, that is Christopher Bivens. He didn't stop to help either. Second, that he waited years to come forward. Well, the reason he waited years, according to William Pierce's testimony, is because he thought law enforcement had the right person. In fact, he thought he was helping law enforcement when he showed up in July of 2014. He wanted to help them. His identification where he said, well, it probably was Thibodeau, law enforcement must know what they're doing. He drew a beard on a photograph of Gary Thibodeau and said, oh, that looks close enough. With regard to the photo array, the court relied on Bill Pierce's inability to identify either James Steen or Gary Thibodeau in a photo array. The reason is, very simply put, Investigator Petrosky said he himself wouldn't be able to pick Steen out in that photo array. He was clean-shaven, he had a baby face, and the photograph they used was something that was taken 6 years prior to the abduction of Heidi Allen.
This is a credibility issue?
It's not a credibility issue because the court was relying on these erroneous conclusions in order to come to the decision that, oh, Bill Pierce's testimony wouldn't change the outcome of the case. Not so. If you take William Pierce's testimony and compare it to Christopher Bivens, it's a determination that a jury should be weighing in on. And in this instance, the court didn't say, oh, Bill Pierce has a motive to lie. He's somehow tied to Gary Thibodeau or James Steen. This is like the case in Bryant where Justice Whalen and Justice Scudder presided, and when the lower court refused to overturn the verdict and grant a new trial based on the two eyewitness testimony. So, and again, just the lower court said, oh, okay, well, I saw a picture of the D&W and there was no snow on the road, and Bill Pierce was testifying that there was snow and slush on the road. Well, the prosecution's own witness, Brett Law, testified that it was snowing on the way to the D&W with Heidi Allen and when he reported back to the D&W after he learned she was missing. So again, the basis in which the court rejected William Pierce's testimony is not supported, but it wasn't a credibility determination. Same holds true if you look at the recorded monitored phone conversation with Jennifer Westcott. The lower court relied on clearly erroneous facts when it rejected the monitored conversation between the girlfriend of one of three new suspects, Roger Breckenridge, and the good friend of hers, Tanya Priest. The court stated, and it's woven throughout the decision, that the three suspects didn't know one another. And specifically, he said, both Steen and Bohr said they never met one another. That's simply not true. That's not the testimony in the record. Michael Bohr testified that he met Roger Breckenridge and James Steen through a mutual acquaintance, Tom Martin. That's cited in the hearing transcript on page 464. Now, in the court's decision, he relies on this factor, and he cites it 4 different times in his decision, all throughout the record. If you pull that thread from this decision, the whole thing unravels because he's relying on this as a basis to suggest that this new evidence wouldn't change the outcome of the trial.
Does Westcott, and again, it's already been said that this is a very large record, but does Westcott testify, though, that she didn't know one of the three prior to this event? In other words, the day that she's supposed to be at the house with Allen in the van, Doesn't she testify that she didn't even know one of the participants?
Jennifer Westcott, her version of what took place morphed over time after she received a message from Roger Breckenridge, who was incarcerated at Elmira Correctional Facility. He relayed a message, and it's in the testimony at the hearing, to tell Jennifer to shut the fuck up about Heidi Allen's case. So her version of what took place morphed over time. Whether she actually had a close relationship with one of the three new suspects is irrelevant. She knows that they brought Heidi Allen over to her house, and you can infer from the recorded conversation that she knew that Heidi Allen was in the van because she witnessed the van in the driveway, and she witnessed the three men in her driveway that morning.
Wasn't her testimony, though, that she didn't know whether it was actually Allen or not, that she just kind of assumed it was?
Well, she said she put two and two together after the fact. And then you also have to remember that Roger Breckenridge later told her what they did with Heidi Allen's body. She testified at the hearing that Roger did say that they disposed of her by burning her body and disposing of the remains in the van. So again, and then Jennifer Westcott was interviewed by law enforcement on 4 different occasions after the motion in this case was filed. And she failed a polygraph examination, and specifically the question about whether she knew these 3 individuals were involved in Heidi Allen's abduction. And in that interview, the polygrapher says we can split each of the individuals out. She doesn't do that. She takes the equipment off, and that's the end of it. So again, the other critical point is that Jennifer Westcott, when she was called down for her first interview with law enforcement, she felt it necessary to send a text message to the junkyard owner. What's important about that is that Tanya Priest's original disclosure to law enforcement doesn't say anything about the van being junked, doesn't mention Richard Murtaugh. That was all solely through the action of Jennifer Westcott. What's most disturbing is that when Jennifer Westcott's phone is being examined on the video by law enforcement, she's referencing, she has to tell them that she text messaged the junkyard owner before she went to the interview. But the defense has never seen those text messages. They mysteriously disappeared after law enforcement took her phone. And that's also reflected in the hearing transcript. There's been no explanation as to where those text messages went. All 3 of these individuals were tied in to Murtaugh's junkyard. So the idea that you can take Jennifer Westcott, it's not just the call, it's the call in combination, the cumulative impact of all of the evidence that was presented that points to 3 new suspects that clearly would have changed.
Let me ask you this question, more pointed than when we talk about the telephone call, because Pierce wasn't called as a witness, correct?
Pierce was called as a witness, yes.
Okay, and Westcott?
Westcott.
How does the evidence get in? How's it admissible?
The phone call is admissible because it's authenticated. The parties have been identified, and on the recording itself, the parties have been identified, and in fact, it's self-authenticating through these witnesses and under People versus Eli as probative and relevant evidence that would be admissible, and a jury would be able to hear it. And again, she's talking about observations of the van in the driveway. She sees that. She admits that she was involved in junking the van with Roger Breckenridge and that she fled to Florida.
But how do you get in, I guess what I'm more concerned about, how do you get in the fact that she put 2 and 2 together by just after the fact is becoming admissible that Heidi Allen was in the van?
This is just like the Tankloff case, as a matter of fact, because in that case...
I found that to be a little bit stronger than this case, but go ahead.
Well, in the Tankloff case, there was a witness that said he put 2 and 2 together that they actually committed a murder because the 3 new suspects were winded and out of breath when they got into the car, and he put 2 and 2 together, and an inference can easily be drawn. In addition to the fact that Jennifer Westcott made admissions that, in fact, Roger admitted that he had taken care of her and disposed of her in a van. So I think the inconsistencies in which Jennifer Westcott attempted to change or morph what she said happened, I think is an inference that the jury would be able to draw that would show consciousness of guilt and clearly would point to the guilt of these 3 new suspects. And I'd also move on to the
Counsel, I'm going to just be aware of your time.
yeah. Oh, and as far as Michael Bohr, the court precluded the defense from developing the record and bringing in the prior bad acts of Michael Bohr, and specifically his attempted abductions of women. And in this particular instance, the Molyneux analysis shouldn't apply in this case because this isn't about whether propensity evidence would wind up convicting a defendant. In fact, it's used for third-party culpability evidence, and we weren't offering it as some freestanding propensity type argument. We were offering it in combination with Michael Bohr calling in false leads right after the abduction. Michael Bohr lived right down the street. He admitted he obsessed about the case. He wrote about the case. He talked about the case constantly. He acted as though he was investigating the case. And then, in fact, his brother lived in the area, and we tried to proffer his brother John Bohr's testimony. We were not permitted to call John Bohr, who was going to testify that he
Counsel,
had...
if I could interrupt you for a second. On the reverse Molyneux argument, you know, we're talking about the modus operandi
Yes.
being similar. Can you address where they're similar? In other words, the specific points of those prior acts and how they're similar to this case?
Well, I think...
To allow for the modus operandi to apply?
The idea that a man would abduct a woman without disguise in broad daylight in brazen fashion, strong-arming, I think that first of all is something that's unique about the situations involving Michael Bohr. It's not every day that somebody walks up to a woman that they hardly know, follows them, stalks them, and we had evidence through John Bohr we offered where he was taken to the DNW by his brother and told to go check to see if the broad was working. The court would not allow us to bring into that testimony. So the women that Michael Bohr previously abducted, he knew of them, it appears, through the fact that they were working or where they were employed, because he was following them home from work.
Well, you come to that conclusion based upon the testimony of the individuals that he drove by. He saw a domestic violence in the parking lot, and that's how the modus operandi. Because on the underlying case, in the underlying case, was there any proof establishing that she was abducted and forced into a van?
Yeah, Christopher Bivens was the prosecution's key witness, and as to what transpired, didn't identify Gary Thibodeau, but identified a van, which also
Well,
gets back to...
he testified that he saw men who resembled the defendant and his brother struggling with a woman, didn't he?
No, he didn't say resembling Gary. You have to look at his description and how they morphed over time. His original description was that the defendant were 5'11" and husky. Gary Thibodeau and Richard Thibodeau are nowhere close to 5'11", and they are certainly not husky. So his identification really premised on identifying the van. And Bill Pierce said, that was not the van I saw. So it was the van that Christopher Bivens was identifying for the prosecution.
Yeah, but Pierce's testimony was that wasn't at the original trial, was it? That was later on.
Pierce's testimony was not, but if you're comparing...
No, I guess what I'm saying is, because I'm trying to get to the point that Justice Whalen was asking about where the similarities. It appears that some of the similarities occurred post-trial, during this hearing, and then relate back to the modus operandi of what you're trying to get in.
Well, and it would be through the idea that there was no struggle in the store, so the struggle must have taken place outside the store, and there was a version of what...
If there was a struggle.
Yeah, if there was a struggle, but as related by Christopher Bivens, then it would be a strong-armed attempt to force a woman into a car, which I would submit is very unusual and something that wouldn't be your ordinary run-of-the-mill robbery, drug transaction, and that sort of thing. But again, it wasn't offered as a freestanding claim of propensity. It was clearly offered in combination with everything we had, including a bracelet that wound up, which we were precluded from offering, and the court misstated it in his November 2nd decision, where he wouldn't allow us to call the cousin to testify about a bracelet that she gave Heidi Allen that mysteriously wound up in her mailbox years later. The important point of her testimony would revolve around her interaction with Michael Bohr, where she would have talked about the fact that she talked regarding the bracelet with her cousin in front of Michael Bohr. So again, it was not simply propensity evidence that was being offered. Michael Bohr testified at the hearing that he had no propensity for violence at all. And that was his reason for telling investigators, there's no way I did this because I'm not a violent man. That's absolutely not true. So again, it wasn't just offered in the context of propensity evidence.
Counsel, you should wrap up.
Okay. Based on the evidence and the suppression of the Brady material, and again, I think it's important to note with regard to Michael Bohr that I didn't mention. I didn't get to address the Brady point in our brief, but I will say this. Michael Bohr revealed during the hearing a fact that nobody, including the prosecution, knew before he testified. He revealed that Heidi Allen's informant information was dropped in the parking lot and found by Christine Duell. After he testified at the hearing in 2015, the prosecution went and looked, and he was right. And it was the first time they discovered this so-called 911 punch card, and it did in fact reveal. And he testified that he knew the day she found the information in the parking lot, he knew about it. And I think that that's an important point to make when you're talking about all the other evidence that points to Michael Bohr. The lower court's denial of Gary Thibodeau's 440 motion was based on numerous legal and factual errors, which only served to perpetuate this miscarriage of justice. And on behalf of Gary Thibodeau, I respectfully ask this court to vacate his conviction. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the court. My name is Greg Oakes. I'm the District Attorney for Oswego County. Your Honors, Judge King correctly decided the 440 motion that was before the court based on the two main arguments that were presented. First, the court concluded that there was not newly discovered evidence that would likely change the outcome of the trial if it was presented to the jury. Secondly, the court properly concluded that there was, in fact, no Brady violation by the prosecution in 1994.
Didn't the court really rule most likely that whether or not it would be admissible or not?
It is, Your Honor.
And so my question to you is this. If the third-party statements were admissible, would it be enough to warrant a new trial in this case? If those statements were admissible on themselves? Because that's really the crux of this case. Okay. Against penal interest, admissibility.
Your Honor, if some of those statements were introduced or allowed into evidence, it may be enough to result in a new trial, depending on which statements we're referring to. But in order to get to, is it substantive new evidence that would result in a different verdict, Judge King correctly analyzed, is it first admissible? And throughout its decision, the court went through each of the witnesses and their proffered testimony and the statements that were attributed to each of these individuals. For most of those individuals, the court found that the statements were speculative, that it didn't necessarily reflect their personal involvement, or the statements were based upon their personal knowledge. And in fact, in many instances, the statements, for say, Michael Bohr, a statement that he made to Tyler Hayes at the bar, there's no indication or no admission of any wrongdoing there. It's basically a guy in a bar who's been drinking who says, I've got a theory, I think I know where she is, I think I know what happened. Quite frankly, you could go to any bar in Oswego County on a Friday night and probably find a few people in the bar that has their own theory on this particular case, and what they believe happened and what they know happened. But again, the court correctly looked and analyzed the evidence in each of those cases. Again, first and foremost, looking at Michael Bohr. As this court asked regarding the modus operandi. Justice Whalen, you're exactly correct. There are no facts that are specific to Michael Bohr's criminal history. The incidents in Wisconsin are important. Absolutely, it indicates a man who at one point in his life was prone to violence against women. But there were not unique facts that tied into this case. In fact, they're very dissimilar. In the two cases in Wisconsin, Mr. Bohr followed women home after work, left their place of employment, followed them in a vehicle into the one incident where she was in a parking lot of her apartment complex, approached her under a ruse, and then tried to forcibly put her in a vehicle. In the second incident, he followed her down the roadway, basically causing her to go off the roadway and tried to force himself into the van. This is done at around 3 a.m. On both of those incidents. The women were alone and separated, essentially doing it on the cover of darkness. Again, those two cases actually aren't even similar to each other because in the one instance he was accompanied by his brother, In the other incidents, he was acting alone. In this particular case, the defense points to the abduction, the forcible abduction of Heidi Allen. Your Honors, that's no different than saying if we had a burglary case. This person went into a home, this person went in through a window and committed a burglary, therefore we should be able to bring in his prior criminal history at every burglary case that comes forward. Again, there are no unique facts. There's no ways in which this was carried out that satisfies the modus operandi requirement to bring in Michael Bohr's criminal history. And again, Judge King thoughtfully reviewed all the proffered evidence to see whether it was remote, to see whether it was speculative, to see whether it would ultimately, if admitted to trial, confuse a jury and get away from the main issue, which was, did Gary Thibodeau commit this particular offense? Now,
What about the testimony of William Pierce?
yes, Your Honor. I think it really does come down to a credibility issue in looking at Mr. Pierce. As the court noted, Mr. Pierce testified that 20 years ago, shortly after the abduction, he looked at a newspaper account of Gary Thibodeau, saw it, drew a beard on it, and in his mind reached the conclusion Gary Thibodeau is the person who did it. Throughout the course of the original trial and all the subsequent publicity, he kept in his mind that he was positive that it was Gary Thibodeau who did it. In fact, in July of 2014, he came forward to the Sheriff's Department on his own and said, I know it's Gary Thibodeau, I want you to know that it was Gary Thibodeau, and gave a sworn statement to that effect. Now, it was only a week or two later when he saw a picture of James Steen in the paper, where he looked at that photograph and then began questioning in his mind, maybe I had misidentified Gary Thibodeau, and then came forward and said, you know, I believe it's James Steen. Counsel noted that, again, there was a photo array in Justice Center. I did want to clarify, when the photo array that was shown to Mr. Pierce, both Mr. Thibodeau and Mr. Steen did not appear in the same photographic array. Because they appeared dissimilar, they were shown two separate photo arrays to see if he could identify either of the individuals in those. Counsel points to the fact that the photo that appeared in that photo ID was 6 years prior to 1994, when James Steen was younger and had a baby face. It was clean shaven without a beard. There's no evidence before the court, and the defense hasn't offered any evidence of what James Steen's appearance actually was in 1994, whether he still had that baby face, whether he had a beard. And in fact, the photo that Mr. Pierce looked at was taken in 2010 after Mr. Steen was convicted of the double homicide. I would argue that a picture taken 6 years before the abduction of Heidi Allen probably more closely resembled this appearance in '94 than a picture taken 16 years after the fact. But again, the court did look at Mr. Pierce's testimony with a critical eye to see, is it reliable? And the court didn't specifically say so in its decision, but as I referenced in the brief, I think it would have been fair for the court to conclude that his testimony was incredible as a matter of law, given that he had made the ID of Mr. Thibodeau previously, held on to that belief for 20 years, swore to it in a statement, and then only changed it after seeing a suggestive photograph in the newspaper amidst all the media coverage that was going on here.
Certainly, the court at the hearing, with the witness before the court, is in a much better position than we are in judging the credibility of the witness.
That's exactly correct, Your Honor. Judge King was in position to hear Mr. Pierce's responses, certain pauses to questions, times when he had to think. Again, the cold record reflects an answer, but it doesn't actually capture the ums and the ahs.
Well, Counsel, let me ask you this question. Assuming that the court was correct, that the evidence would be inadmissible, does this court have the discretion to grant a new trial if we believe there's a grave risk that an innocent man has been convicted?
Your Honor, if this court were convinced that in fact he was innocent, and again, one of the arguments under 440 is that there's that he's actually innocent. The defense hasn't established that in this case, Your Honor. Again, you can look at the record, and if this court were to conclude that it believed he were actually innocent, of course this court could reverse. But given the totality of the evidence that was presented, again, this court, not this particular bench, but this court reviewed the direct appeal. This court found that there's overwhelming evidence of Gary Thibodeau's guilt on the direct appeal. Looking at the eyewitness testimony, again, Mr. Bivens gave a description of individuals that fit the description of both Gary and Richard Thibodeau. Mr. Bivens described being at the store that morning and his purchase, and essentially through him and Mr. Sorkowski established there was a very small window a matter of minutes, a minute or two, in which this abduction could have taken place. And Mr. Sorkowski, in leaving the store, saw a van, saw a person fitting Richard Thibodeau's description walking into the store. And significantly, right after Richard Thibodeau walked into the store, the van moved several feet closer to the doors, which indicates there was a second person who was operating that van. That same van was identified by its appearance, by its license plate by Mr. Sorkowski. Again, he thought kind of humorously when he saw it earlier, it had the license plate that began with PU, and he thought that was very apt and fitting. Well, then we have the testimony of Nancy Fabian, who says she was heading to visit family members that morning when a van, again fitting that description, comes flying up behind her on 104, is driving all over the road. She observes the driver of that vehicle, and though she doesn't specifically identify Gary Thibodeau as the driver, gives a description that in fact matches the appearance of Gary Thibodeau from that day. I think one of the compelling factors for the jury and for this court on its initial review was all of the testimony that was put in before the trial court. Again, the testimony of the jail informants who testified regarding certain statements that were attributed to defendant, but in part, the defendant offered evidence in his own trial originally. And part of that evidence was that he was unaware. He offered his own, that he was not involved, and testified that he was at his home that morning, that he hadn't left, that he was not with his brother, and in fact, that was directly contradicted by numerous witnesses and neighbors who said, we saw Richard Thibodeau there that morning at defendant's home. We saw his van there.
Counsel, beware of your time.
Oh, thank you very much, Your Honor. So again, Judge King correctly looked at all that evidence, and although he didn't specifically recount all the trial evidence, it's implicit in his decision that he examined the newly offered evidence against the weight of the trial evidence and finding that it would not have changed the outcome. Again, the court also then correctly examined the alleged Brady violation, looking at the testimony that was offered by the defense. Again, it can't be overemphasized, the defense has the burden of proof to establish a Brady violation. Quite frankly, at this 440 hearing, the people could have stayed silent on that issue, and it would have been incumbent upon the defense to establish it. In this particular case, that evidence was offered primarily through Judge Fahey. I have great respect for Judge Fahey, but as he testified at the hearing, he hadn't examined the file in 20 years. He hadn't looked at a piece of paper, he hadn't gone over and reviewed anything, was basically walking in cold. I'd submit 20 years from now, if I recall to testify about this case, there are certain details I would forget. There are certain pieces of paper that are critical now that I probably won't recall in 20 years. Again, based upon the quality and the nature of Judge Fahey's testimony, and the fact that he admitted during portions of his testimony he was familiar with certain evidence, that in fact he must have had certain documents during the course of his cross-examination at the trial, the defense falls and fails to meet their burden there. But again, the people offered affirmative evidence to show that in fact the disclosure was made. That was made through former District Attorney Donald Dodd, who testified about his procedure, his notes that he made, notations he had made on the file.
The court specifically credited that testimony.
And the court specifically credited that testimony, Your Honor. And I think that credibility determination's subject to great weight by this court. But even if this court were to look at it and say, we're not sure, or maybe the defense has established it wasn't turned over, there's a second part of the analysis. Would it change the outcome? To be Brady material means it has to be exculpatory.
Well, quite frankly, I find that to be a lot weaker than a former argument.
And I understand that.
We're dealing with a motive now that somebody else might have had, so I don't know if that's your strongest argument.
I don't believe it's our strongest argument, Your Honor. Again, I think the fact that the court credited the testimony of Mr. Dodd and found there was an actual disclosure is the most persuasive. But what I would say is Judge Fahey at the trial, as Attorney Fahey, argued vociferously that Heidi Allen was not connected to drug activity. Because based upon the jailhouse informants, they were saying that the motive for Mr. Thibodeau to commit this crime was a drug-related motive. So the defense did everything they could to separate the defendant from drug activity, Miss Allen from drug activity. And so again, if this evidence were to come out that she was a CI, that it was out there, that means not only did other individuals have the opportunity to know this, but the defendant as well, and it would have led credence that potentially could have been a motive for him to kidnap her. Thank you very much, Your Honors.
Thank you, counsel. People versus Holly.
Morning, Your Honors. Wayne Holly, may it please the court. Today I'd like to focus primarily on point 1 of the brief, and appears based upon the suppression hearing testimony of Buffalo Police Officer Hornberger. As soon as Walisha Turner opened the door, revealing Dwayne Holly lying on the couch, Officer Hornberger immediately entered, grabbed Dwayne Holly, cuffed him, took him out of the apartment, and put him in a police patrol vehicle without verbally asking anyone, either Walisha Turner or Dwayne Holly, for permission to enter or search the apartment. Now, the people claim that Turner's consent was somewhat tacit, and I realize that they presented some case law regarding certain tacit permission to enter, like nods and points. But respectfully, would like to ask the court not to arbitrarily expand what is considered tacit consent to enter. It just can't be just opening a door or just pointing, because there was a certain number of police here. I mean, Walisha Turner was obviously overwhelmed with what happened. As soon as the doors open, the police just rush in. The police conduct was not reasonable under these circumstances, and Ms. Turner succumbed to the will of the police.
I'm not sure that the facts bear out that there was a rush in, but be that as it may, once the police were in the room, if they had justification for arresting the defendant at that time, could they pull him out of the house? Or did they have to leave him there for purposes of then getting permission to do the search?
It's questionable. Well, they had enough probable cause, and I realize they did some police work involved here, but there's no the video that showed the area of where this I think it was a black Mercury Mystique. One of the police officers said they couldn't see who the driver was. So they didn't know it was Dwayne Holly. I know they.
But my question is, if they had a basis for the arrest, assume that just for the sake of argument. Do they have to leave him in the apartment in order to get permission or consent to do the search from him? Or can they pull him out once there's an arrest and then get permission from the other tenant?
They had enough information where they just could have secured a warrant. I mean, if they had done sufficient police work, the black Mercury Marquis or Mercury Mystique was still there. They had sufficient information and sufficient time because the car was still there. They had information that he may have been staying with Walisha Turner at that apartment, so they should have secured a warrant. I mean, they just rushed in, and and they just pulled not only Dwayne Holly out, but they also pulled Walisha Turner out. There's testimony that when they finally asked for consent to search, she was already in the back of a police patrol vehicle. Another officer testified that she was with her child in the police patrol vehicle. There was no reason to pull her out also. I mean, the people state that they did it for comfort, but they could have left her in the apartment.
Well, was there an allegation of a weapon being used?
There was an allegation of a weapon.
And she was in the car, uncuffed, door open, with her child.
Correct.
Now, what would your argument be if they'd separated her from her child?
Well, they could have left her in they already grabbed Dwayne Holly. So he is already grabbed, he's out in the patrol vehicle, he's outside.
Okay, so,
there was no reason to take...
How are we getting to this lack of consent? She ultimately was given a verbal and then given a written, and she signed off on it.
That's correct.
Okay, so we have a verbal permission, and you're saying that the verbal and the written permission was in a coercive nature, and therefore it's not good.
Correct, it was very coercive.
On this point, sir, I have a problem on this point. Who is in the best position to say that their will was overborne and it was coercive? It would be her.
Correct.
Did she testify?
Yes, she did at the trial. Not at the suppression hearing.
At the suppression hearing?
Not at the suppression hearing.
Okay.
But just under the circumstances...
At the suppression hearing, based upon the evidence that it's had.
That's true.
If she testified at the suppression hearing, perhaps...
But it did come out during the suppression hearing that she was... All of a sudden, she was taken out to the patrol vehicle. There was absolutely no reason to take her out to the patrol vehicle with her car for comfort because, I mean, there was a child there. She could have just been seated on the couch for comfort, but they pulled her out too.
But if she felt she was coerced, she could have testified to that.
I don't know if they really allow that at suppression hearings. Suppression hearings are usually the police officers who testify. It would have been up to the DA's office and defense counsel.
Trying to
establish coercion,
establish that it was not a consent, and she would be in the
That's
position
true.
to establish that.
My argument is based upon the totality of the circumstances of the police immediately entering, taking him out of the apartment, then taking her out of the apartment. I mean, obviously, there was some testimony that Dwayne Holly was staying, not exactly residing with the girlfriend, but that it was his girlfriend, and that she was moving in there. And he did provide an affidavit saying he was helping her move, and he did stay there even though he stayed there for a certain time period, even though his legal residence was, I think, his mother or grandmother's, he provided an affidavit saying he was staying there. So it was apparent based upon the case law of Georgia versus Randolph and Fernandez versus California that they were just taking him out to avoid a potential refusal to consent
That's
to
where my
consent to
question
enter.
came from in the first instance. In other words, if there was no basis for an arrest and they were just pulling him out to avoid having him object to the search, then I see the argument.
Yes.
But if they have a legal basis to arrest him, assuming we get there, then the question is, do they have to leave him there to get consent? If they have a legal basis to arrest him, can't they then just pull him out?
There's a question of whether there was a sufficient probable cause for the arrest.
And,
As I mentioned,
I understand that that's your argument. Okay.
Yes.
Thank you. Anything further?
No, thank you.
Thank you, Counsel.
Daniel Punch for the people. First, Your Honor, the testimony at the hearing did not establish that the police just rushed into the door as soon as the homeowner opened it. They identified themselves, they said who they were looking for. She opened the door all the way, exposing the defendant, and pointed to him on the couch 3 feet away. The case law cited in my brief shows that that kind of behavior has been in the past considered tacit consent to enter. Regarding Justice Whalen's question, whether or not they just pulled the defendant out to avoid him refusing consent to search, I believe there was more than probable cause to believe that he had just at least been involved in the gunpoint robbery at the bank. They knew that from the witness, the male witness who was not involved, that he had fit the description of the driver of the car. They had license plates on the car. The grandmother said that the defendant had been driving the car that day. They knew he was at least the driver involved in the bank robbery. They had more than every right to arrest him, take him out, especially in light of the fact that it was a gunpoint robbery. Unless there's any other questions, I'll rest on that.
Thank you, Counsel. People versus Conway.
Good morning, Your Honors. May it please the Court. When someone lies, that person is saying that the truth just won't do. And when a member of the bar lies under oath at an evidentiary hearing on the issue of whether that attorney provided ineffective representation and lies in such a way that no person could reasonably believe it, that attorney is providing affirmative evidence that the job was botched. Sometimes a denial can be every bit as damning as a confession, and this case is illustrative. 2 arguments ago, it was pointed out that the trier of fact, the motion court, is in the best position to determine the credibility of the witnesses who testified. But there's only so much that the style of testimony can do to conceal problems of its substance. No matter how convincingly the witness may have looked when testifying and sounded when testifying, when you say something like, "I'll keep it in my back pocket because I think that's much more effective," for something that was discoverable and that wouldn't have actually, by holding back, you weren't actually hiding anything from the prosecution anyway, two independent reasons why that testimony was absolutely nonsensical.
What are you referring to?
Oh, I'm referring to the first part of
the alibi witnesses. You're talking about the tape. What are you talking about?
I was referring in particular to the weight of the evidence claim with regard to counsel's testimony at the hearing, because it is a significant aspect of the ineffective assistance claim that you have. It's the equivalent of consciousness of guilt evidence. If counsel acted reasonably, what reason could there possibly have been to give testimony like that? You don't shoehorn something like that into your testimony when you've done a good job. I'm not saying that that in and of itself does absolutely all of the lifting that is needed for the defense in
Specifically, what testimony are you referring to?
Well, I'm referring to the testimony of counsel, that is to say, the attorney whose effectiveness is an issue.
Being questioned, right.
What, yeah.
What?
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 I mean, that's the
Kitchen?
What are you saying she withheld, or what are you saying, she lied about?
She was talking about her explaining why she was not either making an offer of proof with regard to either the tape or the testimony by Martinshin, and why she was not bringing that up in jury selection. And this business about how she had these strategic reasons that it's more effective to hold back on this. If she held back, if there was anything that she was actually holding back on, then that testimony shows that she was violating discovery law.
Don't we have to show that regarding the tape, that it would have been admissible?
Well, either the tape or the...
Some likelihood of success?
Either the tape or testimony by Martinshin about the contents of the tape. It is one of the issues.
They don't even know who's on the tape.
Well, I would say a couple of things about that, Your Honor. The first is that these are the short versions before I get into the longer ones. The evidence, the record is sufficient to show that it was in fact Thomas Kitchen, but even if we disagree with that proposition, that shouldn't matter. For all that it matters...
What in the record does establish that the identity of the person who made the record, who was on the recording?
It comes from the following considerations. Number one, March 11 of 2004, it was a person identifying himself as Thomas Kitchen calling the attorney who represented Mr. Conway in this case. 4 days later, Mr. Kitchen, the same person, and it was Martinshin who spoke to him. So he understood when he was making...
How do we know? I mean, I guess I'm tied up on how do we know it's even him?
Well, I would say...
It's not another person. Is there anything in the record that when he showed up at the law office, he produced a driver's license, photo identification? Do we have a copy of that in the record?
We don't have that. There is a statement of the address that was given, but it's a number of different circumstances put together. Those that I've mentioned so far, the fact that Thomas Kitchen then, afterward, went into court on the very day that counsel was to be appointed for him. I mean, is this a completely different person with the same unusual name going into court on the same day that that person was supposed to receive counsel?
Or maybe it's somebody else. It's not him that's trying to go through and help his friend out fabricating a lie.
Well, I would say...
He shows up, he gets cold feet, he shows up late, he gets cold feet, and he leaves.
And
I'm just wondering, how do we know it's this individual?
Well, I would say a couple of things about that. In addition...
That, but I can't, I'm still baffled by it.
Oh, no, I was just going on with it. In addition to that, there's the fact that Thomas Kitchen turns out to be the person the police are ordered to look for, and Roger Putnam is looking for, and Mr. Martinshin is looking for, and they're still never able to find him. So it would be an extraordinary series of coincidences.
They were doing that because that's how he identified himself as Kitchen when he showed up.
I would say, even if, Your Honor, it is assumed that he was absolutely lying about his name, I mean, it could have been Thomas Kitchen or Thomas Selleck so far as the defense cared, because it's somebody other than Mr. Conway. It's, I didn't do it, this other person did it. If the other person, well, I'm lying about my name, but everything else about it adds up, and it is the same person, because otherwise it would have to be an extraordinary series of coincidences. The same person apparently identified by voice by Martinshin in the records. That person goes to court the very day that counsel is supposed to be appointed. That very same person can't be found by the police, can't be found by Putnam, can't be found by Martinshin. If that person, however, just said, my name is Thomas Kitchen, when in fact that wasn't true, then that should not be enough in and of itself to mean that it would be inadmissible. In all matters, perspective is crucial, and proper perspective requires acknowledgement of certain practical realities. When somebody is going to be relying, who is falsely accused of a crime, on the confession of the person who actually did it, if we're going to say, well, if that person lied about his or her name, but it's still the same person who contacted the attorney of the defendant, made a confession on tape in the attorney's office, subsequently showed up to court when that person was supposed to get counsel, subsequently disappeared, if just because that person lied about his or her name, that's not good enough, it would really be, it would have a devastating impact on the ability of wrongfully accused defendants to be able to get this sort of evidence in, which, because of the pardon me, significant doubts have been raised by the people with regard to the reliability of certain issues involving the confession itself. But it is important to be very careful not to accidentally invert the burden of proof with regard to the question of reliability. I didn't have to prove beyond a reasonable doubt that this confession is true. The standard is reasonable possibility that it might be true. So if there are doubts created by the gaps in the record, that doesn't mean it's inadmissible. Additionally, the strategic reasons, there was no reason for counsel not to make an offer of proof. It wouldn't have done any harm. There were significant arguments to be made in defense of the admissibility of the tape or of testimony by Martinshin about the contents of the confession. And considering that this is the same attorney who had the audacity to argue to the court, preclude any mention of a certain piece of stolen property taken from the home because there is no charge of stolen property. And this same attorney has the audacity to say, oh, it would have been bad faith for me even to make an offer of proof. It's a complete double standard here. This is not an attorney who was testifying accurately about the reasons why she did what she did.
Should wrap up, counsel.
Certainly, Your Honor. Well, if the court has no further questions, I can.
Thank you.
May it please the court, Michael Hillary appearing for the people. Before I get into the merits, I just feel compelled to say a word on behalf of counsel here because she's come under some fire in Mr. Williams' arguments. I think the record bears out, and I trust the court will see this, that counsel's reasons for not pursuing an offer of proof with respect to the testimony of Mr. Martinshin as to the confession, the alleged confession by the alleged confessor, are grounded in principles of fair play, rules of evidence, and strategic considerations. This attorney, the record bears this out, did a fine job on defendant's behalf. As to the merits, the defense has not demonstrated why such an offer of proof should have succeeded. It's not given a single reason as to why it should have survived application of the rules of evidence. It shouldn't have succeeded, and therefore counsel is under no obligation to put before the court an offer of proof that she knew and had good reason to know would not have succeeded. All we had, and this is her testimony, was a voice on a tape. In her discussions with the first attorney, Mr. Martinshin, the one to whom this alleged confession was made, she said, and I gathered from Mr. Martinshin, really all I gathered, was that his name was Thomas Kitchen and little else. Nothing else, essentially. So we have a piece of evidence, if you will, that has profound, and understandably so, potential impact on the minds of jurors, because you have another individual out there who's confessing, without any way for the prosecution to legitimately test it. And if we're going to rely on Mr. Martinshin's memory of what was said, because remember, this, according to the record, this confession to Mr. Martinshin would have been made months before it actually would have been put before the jury. We're going to rely on Mr. Martinshin's memory as to what those convincing details were, and leave the prosecution in a position purely to thrust at it with speculative, theoretical concerns as to why you shouldn't believe someone coming in, with very little opportunity to address the factual substance of that confession, assuming, of course, that Mr. Martinshin doesn't have a pristine memory of those convincing details. So I believe that counsel here did a fine job on defendant's behalf, kept this individual on the witness list should developments occur that justified putting him on the stand and going forward in that regard. And it should not be forgotten, and I have a penchant for stating the obvious, but I think it bears repeating here. This defendant pled guilty. He acknowledged guilt. And that's all I have to say unless the court has questions. Thank you.
People versus Stevens.
If it please the court, Kurt Hameline for the appellant, defendant, Michael Stevens. There's really only one issue in this case, and the issue is whether there was probable cause to arrest the defendant for the offense of disorderly conduct.
This is totally unpreserved, right?
There was a motion to dismiss at the end of the People's case, which was vigorously argued. I don't believe that there was any additional evidence which would have helped the prosecution's position during the defense case. Was there a specific objection made at the end? No. Yeah, the answer to that question is
So
no.
it's unpreserved.
It's unpreserved to that extent, but I believe, in view of the fact that the jury found the defendant not guilty of the disorderly conduct count, which is the count which starts the entire chain of events in this case, I think that the issue is then available to the court for its review, and of course the court can review it in the interest of justice.
Of course, there is a different standard of proof beyond a reasonable doubt at trial, as opposed to what the officer is confronted with on the street, and that's a probable cause or a reasonable cause standard.
Absolutely, I agree with that 100%. If I could get into the facts just very briefly so that it's clear. This incident took place on March 14th of 2015. It's the day of the St. Patty's Day parade in Utica, New York. And the parade used to be on Varick Street, and now it's on Genesee Street. But the Varick Street area is known as the Brewery District, and there's a number of bars and taverns and restaurants. And after the parade, the police cordon off probably about a 4 or 5 block area, and there's a general all-day party that goes on. There's food, there's beer, there's music. Hundreds of people go to this event.
Counsel, we'll let you get into the facts briefly, but we're familiar with the facts, so we know how this all transpired.
Okay. Well, I just wanted to be clear that the defendant was confronted by the police at about 1:30 and asked to leave the area, which he did. His mother was called. His mother came down to pick him up. His girlfriend and his brother's girlfriend went to use a bathroom in the restricted area. After about a 20-minute wait, he decided to go back in and get his girlfriend. He found his girlfriend in a bar called Shots. They left. They were walking down the street, headed towards the mother's car to leave the area. As they walked down the street, the police made an observation of the defendant and the defendant's girlfriend. They testified that she appeared to be in distress, that she seemed to be signaling for help, which he denies, and none of the other witnesses other than police officers state that. At that point, the police approached the defendant. There's a very brief interaction between the defendant and the police in this case, and the police tell him he's under arrest for disorderly conduct. Now, the theory that the officer testified to...
Didn't immediately preceding that, they asked him to move along, and he said, the only way I'm leaving here is in handcuffs.
That's the testimony of the police officers. Okay, the defendant denies that, but that is the testimony of the police officers.
For purposes of determining whether or not to make this arrest, the officers have taken into consideration the totality of what's in their mind at the time, and we look to what they testified to. You seem to somehow or another separate those two separate instances, like the officers could not have had in the back of their mind or part of the rationale the first meeting as opposed to the second meeting. But if the officers could utilize the whole transaction from when they told them to leave the first time to the second time, the question becomes is whether or not there was reasonable cause to arrest the defendant, reasonable cause to arrest the defendant for disorderly conduct.
Correct.
Not guilt beyond a reasonable doubt.
In the first encounter, the defendant complied. He left the area. His only reason for returning was to get his girlfriend and go to his mother's waiting car.
When you say left the area, though, he was directed to leave.
And he did leave the area.
Party area.
He left the party area.
Yeah.
And he waited approximately 20 minutes or so for his girlfriend.
Well,
Then
I think what you're overlooking, at least I'm, is that what took place in the first incident, he was almost in a fight, head butting or chest bumping or doing something. There was some aggressive behavior.
there was a dispute between he and his brother. His brother was trying to calm him down.
What did the police officers testify to? It was a little more aggressive than just his brother explained to him to calm down.
I don't believe there was any testimony that it was physical in any nature. The brother testified that he put his hands on his shoulders, trying to calm him down. They're there to have a good time. He was upset because his girlfriend had received a text message from an old boyfriend. That's what this whole thing was about. And they were arguing. The police asked him to leave. He left. Then he returned. He went to the Shots bar, got his girlfriend, was walking down the street. It was about a block and a half from his mother's waiting car. He was not congregating with anyone.
I was going to say, now, assuming all that you've said here, I mean, the issue comes down to congregating, doesn't it? That's really what you've argued down below, and that's the issue.
Absolutely.
Now, does he have to know the names and identity of the literally hundreds of people that were there?
No, but I think if the way the court charged the jury what the definition of congregate means, and I think what the Carcel case, which obviously is an older case, and it looked at the disorderly conduct statute, which is almost identical language to what is presently in the penal law. Right. It says congregate means to assemble, to come together with at least 3 other
Well,
persons.
there were hundreds of people there.
But there were hundreds of people there, but he was not congregating with those people. He was walking down the street.
So
And if
when he goes to when he goes to this St. Patrick's Day festival, he's not congregating with other people? That's pretty much your argument, isn't it?
My argument is that, based upon what the Court of Appeals has said, that's not congregating. There could be other people in the area. He is not in any way associated or hanging around or intermingling with those people. In this particular case, he was walking down the street, leaving the festival. He was not mingling with, he was not partying with, he was not a part of any congregation. In the Carcel case, I think that if the court looks at the Carcel case, it's giving that direction to us, that it means more than just other people in the area.
So if I go to this St. Patrick's Day party with 6 friends, the congregation is me and the 6 people.
Correct.
It's not the other 150 people who are at the festival. I'm not congregating with them. I'm only congregating with the 6 people I called ahead of time to go to this festival with.
I would say that's correct. I mean, there are other people present, but I mean, if you took that definition, anytime there were other people in the area, then when a police officer told you to move on or to leave, you would be committing the offense of disorderly conduct.
No, there's the other element of disorderly conduct, and that's by intentionally causing public inconvenience, annoyance, or alarm. So if you're just sitting there quietly, I don't know how you could be accused of creating public inconvenience, annoyance, or alarm. I mean, there is another element to this statute.
But he
more
was,
than merely conduct.
but he was not doing anything in that point in time that would satisfy the disorderly conduct statute.
Well,
He was having a private discussion, a private argument with his girlfriend as they left the
You
festival.
have to give us this much, okay?
Yes.
It wasn't so private that the fact that a couple of vendors heard him screaming, and the individual, I think it was a correction officer, was on his way over or something to make sure that it didn't get out of control. So you make it sound like he's having this pleasant conversation.
No, it was an argument, there's no question.
And
I
it
mean,
was a loud argument.
the corrections officer heard there was.
Excuse me, it was a
Okay.
loud
Yes.
argument.
Yes.
So people could hear. The officers became aware of it.
The court has to also look at what was going on. This was a festival. There were hundreds of people on the street. There was music, there was noise. There was no way that he was engaging in any activity which created public harm or a risk of
I
public
think
harm.
we have that argument, counsel.
Thank you.
Thank you.
Good morning. May it please the court, Steve Cox for the people. Of course, first I agree with Justice Scudder that the essential question of whether reasonable cause existed here and was shown by the evidence at trial is not preserved. The question also, I think, Justice Joseph, of whether congregation was shown is not preserved. Should the court reach those issues, I think the simplest explanation is I don't know everybody's name in church, but I'm congregating with them. I don't think that any of the cases in this area have been limited to say you must be of like mind and with friends or associates to be congregating with them. We have, about 18 years ago, the experience of hosting Woodstock 99 in our county. Now, there were about 300,000 people congregating there at that time, and as you know, it ended going up in flames. The essential point of this case is it's about the right of police officers in special situations like this to maintain public order. I think the Officer Goldstein enunciated specifically what he saw and what he believed. The near brawl involving the defendant some minutes earlier, and then the female who'd been with them at the time approaching him. He described it as running towards him, being pulled at the shirt by the defendant, saying, "Get him away from me, get him away from me, help, help." 3 other officers in the vicinity had similar accounts. All said, she said something to the effect of, "Get him out of here, get him away from me." And that when they stopped to just first separate the two and talk to the defendant, they again asked him to leave. They again gave him a lawful order to leave the premises, keeping in mind they had already done that once, and I think would have been in their right to simply arrest him at that point for violating the first request to leave. But he refused 3 more times to leave, and as you mentioned.
That's the time when he said he'd be willing to leave, but he was leaving in cuffs.
Right, exactly. And so at that point, given the totality of the circumstances around you, hundreds if not 1,000 people on this 4-block festival street, there was a great risk I think, as Justice Joseph mentioned, you have to consider the annoyance or alarm factor, but the judge also carefully read a section of the charge he missed, saying that the defendant could have simply recklessly disregarded the risk of creating annoyance and alarm, and the police were justified in effecting the arrest at that point.
Thank you, counsel.
Thank you.
People versus Taylor.
Good morning, may it please the court. I'd like to address the sixth issue, the issue relating to the 440. And so the court is aware this is a consolidated appeal, so it's both the direct appeal and the 440 appeal, or have been consolidated for purposes of briefing. And in particular, I'd like to address the fact that the court denied the defendant's 440 motion, and he raised a very viable Brady violation. He alleged the fact that one of the prosecution witnesses had 3 prior convictions that hadn't been disclosed to the defense. And
They never gave him a rap sheet, or they didn't run a rap sheet on this witness, apparently?
it is apparently so, and this issue is really intertwined with other issues in the brief. The defendant had argued that he had an actual conflict with his counsel, a member of the public defender's office. Now, his trial counsel was not the one that represented him previously, but the public defender's office had represented him 3 times prior.
Nobody knew about that, though, did they, until after the trial?
Well, and they probably would have known about that had there been a rap sheet and the Brady the previous convictions disclosed. Now, counsel, the district attorney's office also mentions or argues that, harmless error, because these are 3 old convictions. Well, interestingly enough, I also argued a Sandoval issue, and the court had allowed, as to my client, convictions from 2001, 2006, and 2007. But now when it comes to Ms. Timmons, the key prosecution witness, her convictions from 1998, 2001, and 2006, fairly similar in time to my client's convictions that were allowed into evidence, now aren't going to affect his credibility. But they're certainly important to destroy my client's credibility. Same type time frame.
The question is whether it would have been a reasonable possibility that the information would have changed the result. That's the test.
I think that there certainly is a good that there is in this case.
That there is a reasonable possibility
Absolutely.
that it would have changed the result in the proceeding.
Ms. Timmons was not the most forthright witness. Testimony in this case was very inconsistent.
Let me ask you this question. I know I understand you're taking aim at Ms. Timmons, but and we got so many cases on today. My head's but I guess the question I have to ask you: didn't a police officer testify that he saw a gun in his hand? I mean, that's to me. Once the officer says, "I saw a gun in the hand," and then everything after that's pile on. So you have to not only say that Ms. Timmons was wrong, but the officer committed perjury by saying that he specifically saw a handgun in his hand. That's, to me, going back to Justice Scudder's question.
There's a lot of inconsistencies in the officer's testimonies. There's testimony of the angle, his ability to see where he was at, and I also have been preparing for a number of cases, so I'm going to refer to the record here, or refer the court to the record. But there was an inconsistency about the time that when consent to search was granted, when he was Mirandized. It just wasn't, police officer after police officer saying, I saw a gun. There was one officer who said he saw a gun, but there was also the 911 call was that Miss Timmons' nephew was being pistol whipped on the porch. No evidence, the nephew was never brought in, no evidence of anybody pistol whipped, no evidence of anybody injured. So the testimony in this case was just, it wasn't clear, it wasn't overwhelming, it relied heavily on the credibility of the witnesses. This is something that went directly to the credibility of a key prosecution witness. And I think that it certainly warranted a reversal. However, in the alternative, this was a summary dismissal on the 440 motion and at least warranted a hearing on the motion, particularly in the way that this is just, it becomes very intertwined in the other issues in the case.
Thank you, counsel.
Thank you.
Good morning again. If I could just clarify in regards to the 440, what we are talking about here that the defendant set forth in his pro se 440 was that there were convictions from 1993 for petty larceny for Ms. Timmons. And what actually came to light was while this case was being prepared for direct appeal, the public defender's office sent a letter informing this court that their office represented Ms. Timmons in 1998, 2001, and 2006. No one has ever alleged that those charges that the public defender's office represented Ms. Timmons on ever came to a conviction. So we have no recent convictions whatsoever. The Sandoval issue in this case is unpreserved. I won't discuss that, but I do want to clarify that it is the public defender's office responsibility to run a conflict check. And in this case, Ms. Timmons was involved in this case from the beginning. She wasn't some witness that fell out of the sky at the time of trial. In the discovery packages, which I guess would be to horse the record, but she is the one who's involved. She's on the 911 call. This isn't a mystery to the public defender's office that she is going to be called as a witness.
I understand that they have that duty on the conflict check. Do you have a duty to run a rap sheet on your witnesses?
Absolutely, we have that duty. There's no question. There's no, I cannot say that it did or it did not happen, Your Honor. The record is silent as to that issue. The trial prosecutor no longer works for our office. I really cannot say one way or the other. I can say that even if it wasn't turned over, this was a 15-year-old petty larceny. Ms. Timmons was basically portrayed as a drug user who stayed home all day in this family, associating with people using drugs with her grandchildren.
The rap sheet though may have shown whatever happened to those 3 or 4 subsequent, those arrests that happened thereafter.
Absolutely.
She may have a more serious record than we're talking about.
Absolutely, but then the issue goes back to the fact that this is a 440 motion and the burden is on the defendant to show that, and I don't think we can blanketly say that those things happened in this case. And it is very clear there was no actual conflict, that Mr. Stubbe was not even a member of the public defender's office or the New York State Bar at the time that her convictions accrued. So I would ask the court to affirm. Thank you.
Thank you, counsel. People versus Switz.
May it please the court. Good morning. If I might, I'd like to start with my second point, move to the first point, and then move on from there if there's time. The second point is the Batson challenge here. The court will recall that during a round of jury selection, the prosecutor used a preemptive challenge against the only Asian juror, potential juror on the panel. And while the challenges were being exercised, counsel did register his Batson challenge on the ground that this was the only Asian prospective juror on the panel. In response to that, the prosecutor articulated 3 reasons, ostensibly his attempt at non-pretextual reasons for using preempt against this particular juror. The first was the concern over the juror's stepdaughter, knowledge of the stepdaughter's involvement with the criminal justice system. And that we would submit was pretextual. The juror indicated that, yes, she had a stepdaughter that had been involved in some sort of criminal history in an adjoining county, She apparently did not know what that criminal activity was. She didn't say how old her daughter was. She knew essentially nothing about that particular case. So we have no way of knowing, nor did anybody in that courtroom at that particular point, that this particular knowledge, such as it was, and knowledge in very small letters, would have any impact upon her ability to be fair and impartial. And in fact, she was asked, would this have an impact? And she said no. The prosecutor in their respondent's brief indicates that, well, that doesn't prevent her from going home at night, learning the details of that, and essentially eliminating that fairness and impartiality. I think that can be said with respect to any potential juror, that they can go home and change their mind about something they've said during the course of the voir dire. So pretextual that it was. The second one was that the prosecutor said, I had a feeling she just wouldn't be a good fit, and those are the words that were used. What does that mean exactly? There was no articulation of that, what that meant.
Didn't the prosecutor, and correct me if I'm wrong, didn't the prosecutor make reference to body language?
Yes, but never said what that body language was. Was she fidgeting? Was she looking down? Was she, wringing her hands?
But body language is something certainly in voir dire that's a valid thing to take into consideration. Wouldn't you agree?
It may very well be.
So your argument is that it may have been a valid reason, non-pretextual, but that it wasn't articulated specifically enough.
Correct. And without an articulation of what that offensive, if we will call it that word, body language was, we don't have a record here to judge whether that was pretextual or not. And if there was some...
But the court has great discretion in these rulings, right?
No
to
question.
Make those determinations.
No question about that. But there's no record here. I mean, we have an articulated Batson challenge. We have an effort made to articulate the non-pretextual reasons. And we have the court making a ruling, but without spreading on the record the basis for that. So what we have is this bare, it's not a good fit, her body language. And then the third reason is that this woman works as a cleaning lady for the judge's law clerk. Again, pretextual here. So what? I can't come up with a better response than so what. I have a cleaning lady. I would imagine that some members of the panel have cleaning ladies, or their households have cleaning ladies. Do they know what we do every day? And would we have an impact upon them were they sitting on a jury? That's just, to my mind, that's the essence of pretext. So whether we measure the judge's ruling denying the Batson challenge in terms of was it an abuse of discretion or was it de novo, which this court seems to have advocated in its past decisions, I think the bottom line is that she should not have been permitted to be stricken from the jury with a preempt in this particular situation. Moving on to the first point, which is the, for lack of a better word, excuse me, the rape shield law, the evidentiary rulings here. One of the key pieces, well, this whole case was founded on when the first sexual contact occurred, ostensibly when it occurred. And the case built from that. The last piece of evidence, if you will, was the controlled telephone call that the police set up with the alleged victim here. That phone call was really a pretty key piece of evidence here. Because of the language that was used during the course of the phone call, I think that anybody would say it's cryptic. What happened when we were young, what does that mean? Well, certainly with the testimony of the victim and the implications that testimony created, it's that this is all the sexual activity that she's testifying occurred over the course of these months/years. In limiting, and in some cases precluding, the defendant from introducing evidence to explain that, I can come up with this: what's good for the goose is good for the gander. If you're going to put it in and you're going to create this impression, if not explicitly testified to, this is what I meant, should the defendant not have the ability to say, that's not what I meant when I answered that question in that
Well, the
way?
court made a ruling, right? And the court allowed testimony, but under the rape shield law said you can't get into the specific sexual conduct of the victim. In other words, the court was saying you have some leeway there, but just don't go into the specific conduct.
It did and it didn't. It limited his ability to talk about, or the defense evidence to talk about her prior drug use, but it essentially eliminated any aspect of the prior sexuality. It said, well, you can talk about that you just didn't want her to talk about her sex acts.
I know,
or
but the problem is, by this coming out, and I understand that this is a close issue, at least in my view, but I understand the fact that what he would have been talking about would have been regarding her sexual activity with at least 2 other people.
Presumptively, yes, the son and the other
So
boyfriend.
unidentified and other.
Right.
I guess your point is if they put in this ambiguous tape,
Correct.
someone ought to be able to explain the ambiguity, or at least my side of the story.
Correct. And in limiting the testimony the way the court did, it prevented the defense from getting into that. Finally, the last thing I'd like to talk about, if I might, is the effectiveness or ineffectiveness of counsel here. I guess I would applaud counsel's truthfulness in starting out by telling the jury, gee, I'm inexperienced. I really forgive my inexperience. You've got this really, really experienced prosecutor over here. I'm just, the Sam Irvin, I'm just a country lawyer kind of thing. But as the trial played out, what played out was really that he didn't have a good handle on what it was he was doing. This business about the flash drive that came out during the course of the 440 proceedings, which the court has before it as the consolidated appeal, seems to be the morning for 440s, by the way. I mean, an experienced trial attorney who knows nothing about that kind of thing, a flash drive, a police report, a photograph, wouldn't an experienced, meaningfully representing lawyer have immediately tried to move for a mistrial, at least an adjournment of the proceedings, to find out, where's this flash drive? What's on it? What's it all about? Doesn't do that. But the real, I think, the big issue here with respect to ineffectiveness and the lack of meaningful representation is how this attorney handled the very core of this case, which is, when was this first incident? When did it occur? That was the one on which each incident built, and the age of the victim was determinative here. You're trying to prove that the room in which this first incident, the victim says this first incident occurred, wasn't even constructed at the time the victim says, we had sex in that room, or he touched me in that room. You'd go in with the testimony of, solely the testimony of 2 related individuals? I can't imagine doing that.
Is there some offer of proof regarding some purchase of building materials at Home Depot or something?
Which again was not, it wasn't backed up. It was, once again, using our own experience, we get bills every month, our MasterCard bill, our Visa bill, Home Depot, Lowe's, whatever. Who says what we bought then? Why not go and get the receipts? They can be obtained, may take a little bit more work, but they can be obtained. Show that drywall was purchased. At least that's a little bit better than your wife comes in and says, oh, the room wasn't there. So if you look at the totality of the representation, while he did some things very well, he made the Batson challenge, that's where I let out. He did cross-examine certain witnesses, didn't cross-examine others, and certainly didn't cross-examine the victim.
Counsel, you need to wrap up.
I think his representation fell below our Baldy standard. For all of the reasons I've stated in my brief, I would ask that the conviction be reversed. Thank you.
Thank you, counsel.
Good morning, may it please the court, Amy Hollenbeck on behalf of the people, to address defense counsel's arguments somewhat in the order that they were presented. In regard to the Batson challenge, in regard to the first issue, the juror's daughter who had some kind of criminal involvement, I would submit to the court that the things that the defendant is looking for are things that would substantiate a challenge for cause, and that the people are not required to show that this juror could have been dismissed for cause, and that's exactly what a preemptory challenge is all about. And removing a juror because they or someone in their family have some sort of involvement with a criminal conviction is pretty standard preemptory challenge. The prosecutor did, in response to the 440 motion, indicate that in his mind he didn't know what was going to happen when she went home, because she said, I don't know what the crime is. Just because she said, I don't know what the crime is, what the prosecutor was saying is, I'm not required to sit and speculate as to whether that crime, if she does find out what it is going to have some effect, or if just the fact of the conviction is going to have some sort of effect. I know she said it wouldn't have any effect. If she had said it had an effect, it would have been a clear-cut challenge for cause. We're not required to go to that standard before deciding that this is not a juror that the people are comfortable with.
Does counsel have to articulate more than body language? In other words, the specifics of the body language in order to
And then, I don't believe so, Your Honor, and I think the case law is pretty clear that demeanor is a basis. And he didn't just, there are some cases that when a prosecutor says, well, I just got a bad feel. That may not be enough. But when he said the body language makes me uncomfortable with her with the victim, or some words to that effect, I think what he's talking about clearly is demeanor, and I think the court is in the best position to both see the demeanor of the prosecutor and the witness and the juror.
Counsel, isn't it a bit of a problem, though, if we agree that I have a feeling maybe doesn't get you there, but body language does, without further articulating, as counsel's arguing, what about the body language?
I think there is a difference, because body language is a feeling is his own personal reaction. Body language is, I have made an observation of this person, and based on my observation of this person's actions, not their height, their color, their whatever,
body language is something
of their
that you
actions.
can make, counsel, if I can finish, body language is something that you can be taught, you can understand it, it can be trained, and it can be utilized as a tool in jury selection.
Yes, absolutely. Thank you. In regard to the rape, well, in regard to the cleaning lady argument, just briefly, this wasn't about her employment because she was a cleaning lady, or she could have been a plumber, or she could have been a lawyer, or she could have been a doctor. It was because she had that relationship with the court. And I think the court's questioning of her about that, clearly it was appropriate, and it was not inappropriate for the people to decide that she's got too close a connection here. I'm not comfortable with that situation, and use a preemptory challenge. And there's nothing in any of that that would indicate that any of those reasons are were anything but facially non-discriminatory. In regard to the rape shield law, in regard to the phone call, I think
Watch out for the phone call. What were you trying to prove with the phone call?
I think, I can't say. I was not the prosecutor in the case, and I can't say directly, but I would say it's pretty standard procedure to do a controlled phone call in those situations.
And oftentimes they're very inculpatory.
Right, and sometimes they are,
and
sometimes they aren't, and this one was pretty vague. But I think that the court fashioned a limitation that allowed the defense to offer a reason for saying, yeah. All the defendant said was yeah, basically, in response to her statement about things that happened when we were younger, yeah. The court allowed him to say I thought she was talking about, first of all, this is only what he thought. And he thought she was talking about her drug use, or he thought she was talking about him having told her not to make sexual commentary. That's a completely reasonable explanation for him to say, yeah, it was part of, it made sense, and the court allowed him to give that part of the explanation and merely limited the part of the explanation that was, oh, and by the way, I thought she was talking about all the sex she had with all her other boyfriends. I mean, there was no reason for that to be included in there in order to allow him to give an explanation. His defense was well protected by being able to give those other responses. In regard to the, and also I think we have to remember that there has to be an exception under that rape shield law. That rape shield law is, this does not come in unless there's some good reason in the interest of justice or one of the other enumerated reasons.
There's some testimony about a morning after pill.
Oh, boy. There were two morning after pill incidents. The first one was, she testified, if I'm paraphrasing it correctly, basically that after one incident, he gave her a morning after pill because he was concerned that she might have gotten pregnant. It made her sick.
He was never charged with having intercourse with her.
Right. He wanted to put on his own, when he testified, to say that I did give her the morning after pill, but I did it because she was worried that she had gotten pregnant from an incident. She had missed her period and she thought she was pregnant.
Because of his son.
Because of his son, I think it was.
He was trying to really protect his son.
Right, yeah.
But does that make any sense in terms of a morning after pill after missing?
No.
The woman missing her period?
No, that part of it didn't make any sense. And the other thing was, this was just in the defendant's mind. And in reality, if he got up there and testified and said, yes, I gave her the morning after pill, but no, I never touched her, he's essentially saying the same thing without saying, and by the way, she was sleeping with my son. He's saying, I gave her the pill, but I didn't give her the pill because it was for me. And that testimony, I would argue, is properly limited because what he wanted to put in doesn't address whether or not he was having sexual contact with her. It only addressed whether she was having sexual contact with somebody else, or he thought she was. It doesn't talk about it doesn't give any more information about their relationship. She could have been having sex with other people. And then there's the other morning after pill, which was, he says that she asked for the morning after pill. This is long after all of the allegations had ended, 2 years or a year and a half, I don't recall exactly, and that he thought that was her motive for going to the police about this because he says he didn't give her one. And again, it's the same. There's nothing to back that up. There's no, unlike in the case where there are all the emails and it goes to a consent issue about whether there was consent between the parties. This is just his version of what her motive might have been. It was purely speculative on his part that was her motive. In regard to the ineffectiveness assistance of counsel, I would submit that counsel was very effective in this case. He did a great cross-examination of the child abuse accommodation syndrome expert. He did his best to get that evidence in spite of the rape shield law. In regard to the flash drive itself, there's a separate argument on the flash drive, but he received a copy of the typed version of what was on the flash drive. I think I've referred to it in my brief as the written version or the typed version. What he didn't get was the flash drive version. First of all, there's no difference. And I think that when the 440 motion, when this all came out, the court reviewed it, the defense attorney who did the 440 motion reviewed it. There was nothing different about that flash drive from what was on the typed version. And I would submit when defense counsel got the typed one and he heard there'd been a flash drive version, he had no reason to presume there was anything different and that his actions were not inappropriate. Thank you.
Thank you, counsel. Percola versus First Choice Realty, Inc.
Good morning. On May 30th, 2013, the Honorable Glenn T. Bruning, Court of Claims Justice, did render a decision order directly relating to Judge Grove's so order dated July 28th, 2005.
Sir, it appears that judge's decision basically said the proper way to attack that is by way of a motion to vacate, correct?
Your Honor, I don't hear it too well. I lost part of my hearing in the Army, and I didn't hear what you said.
That decision dealt strictly with the fact of the actual procedure in order to go after, to attack Justice Grove's prior decision. That wasn't a directive that you have to do it.
Yes, there was a procedure, Your Honor, in the Court of Claims. And the record has Judge Bruning's decision and how he arrives at the fact that Judge Groves' so order should be vacated based on the CPLR 5015A4.
Let me give you a little notice here. We've heard the case, we've heard the prior case, we've made a decision, we've made a ruling, and we've done it more than once. And so, if you didn't like our decision, your chances were you should have gone to the Court of Appeals. A Court of Claims judge can't dictate what this court does. I'll make that clear to you. And when I read the decision from that judge was basically saying the proper way is to vacate a prior court's decision. That ship has come and gone. We're talking about a 2005, 2006, 2007. We're talking about an old case. And in fact, you were ordered by the lower court down below, if you recall, okay, not to bring any further actions. You did. The court found and gave you cost. We affirmed the lower court by saying it was res judicata and you can't bring the action. We sent it back strictly and solely for the court to give you the opportunity and afford you the opportunity pursuant to what the statute requires. So what's before this court right now, I don't speak on behalf of my colleagues, but the way I look at it, what's before us is whether or not the lower court properly imposed $1,200 in cost. And I'd appreciate if you would keep your arguments to that area, and then we will look at the other stuff, because the other stuff is different. Deal with the cost.
Well, excuse me. Well, Your Honor, the case was up here and it was sent back to the lower court.
And I was on it, and I'm familiar with it.
And we were going to argue there the sanctions.
Correct.
And from the sanctions, I did appeal, and I'm here now.
For the sanctions?
On the sanctions.
The amount of the sanction.
Yes.
Okay, and that's what I'm saying.
And what constituted...
Let's focus in on the amount of sanctions.
Right. And
Why
what
is
constituted the sanctions.
Are you arguing that $1,200 is excessive?
Yes.
Tell us why.
Yes. And I'm also, excuse me, and Judge Bruning's decision is directly related to the $1,200 sanction. So that's why I am presenting Judge Bruning's decision, because it does affect that $1,200.
Because you're saying that Judge Bruning told you that this is the avenue and you followed that court order?
Yes.
Okay, then we have that. I understand that.
Yes. So,
why is the $1,200 too much?
I'm sorry, Judge?
Why is the $1,200 too much?
It shouldn't be any, because I followed a path that the judge here had ruled on, and I don't see why I should be penalized at all.
So
here's what the judge had to say.
Sir, let me make it easier for you, because I know you're not an attorney. Make it easy. Your argument is based upon the Court of Claims judge's decision.
Yes.
You followed that. Therefore, the court improperly opposed attorney's fees because all you were doing was following another court's directive.
Yes.
Okay, we have that argument.
Yes.
We understand your argument.
Right.
Okay, so.
And that argument you can find in the record. It's in the record.
No, we have it.
On page 97.
And I've read it. We've read it.
So on top of that, along with the sanctions, why I should be sanctioned at all, Judge Bruning did decide, and this is why I brought the original motion. He did decide that the CPLR 2104 provides, in relevant parts, an agreement between parties or their attorneys relating to any matter in an action other than one made between counsel in open court, is not binding upon a party unless it is in a written subscribed by him or his attorney, or reduced to the form of an order and entered. He continues with a stenographic record created outside of the judge's presence, which was in this case, in front of the judge's law clerk, which happened here, is insufficient to comply with the CPLR 2104, where the transcription was neither subscribed to nor reduced to the form of an order.
Okay, what's your point in reading that?
My point is, this is the combination of Judge Bruni's path that he gave me to proceed to vacate this order, and the reasoning for vacating this order is combined together, which is how I proceeded.
Which is, you've already made that argument. We understand that argument.
Well, what I'm saying is that it's a combination of the path that he gave me, and it's a combination of him saying you can vacate this order because it doesn't stand up to the CPLR 2104. So my point is that I shouldn't have been sanctioned. I just went along and when you can't take the decisions of a judge and proceed accordingly, who can you rely on?
Thank you. We have your argument. Thank you, sir.
I think that this order should be vacated on top of it.
We understand that your relief that you're requesting. Thank you.
Thank you.
Your Honor, just briefly, this matter was remitted to Judge Hester because he had not set forth the basis for imposing sanctions. Judge Hester has now done that. He went through and listed all of the many cases that have been before his court where he directed Mr. Ficola not to file any more cases, and Mr. Ficola continues to file cases. And therefore, I think the sanctions were appropriate, and the amount of attorney's fees awarded were based upon the amount of time spent.
Thank you, Counsel.
Thank you very much.
Aikon versus State of New York.
Good morning, Your Honors. Allison Levine for the State of New York. In our brief, the state set out the ample evidence below, clear and convincing evidence, in fact, that appellant has serious difficulty controlling his sexual offending conduct. In light of my adversary's decision to submit, I'm simply here to answer any questions this court may have.
Thank you.
And if there are none, I'll rest on my brief.
Very good.
Thank you.
Thank you, Counsel. Horvath versus Hutchinson, Jr.
Good morning, Your Honors. If it please the court, I'm Lionel Lee Hector for the appellant. I have nothing to add to the brief that I gave you. I'm here to answer questions.
Well, thank you. No questions? You may sit down. Counsel?
May it please the court, I'm Keith Coughlin for the respondent, the plaintiff wife, the late Judith Hutchinson. The trial court had jurisdiction in June 2015 to sign the judgment of divorce, nunc pro tunc, based on the Cornell exception. Generally, a matrimonial action would abate and may not then be prosecuted as a survivor action unless or except if all matters are resolved and only the ministerial act of signing the judgment remains.
Sir, could I ask you this? It appears from my reading of the pleadings in this case that the defendant never denied any of the material allegations of the complaint relative to the divorce.
That's true.
He admitted that. So really, there was never a problem here with the divorce itself.
No, the divorce was resolved by the parties, transmitted to their attorneys, to the plaintiff's attorney to write up as a stipulation, signed by both parties, subscribed by both parties. Mr. Hector subscribed his client's signature. No, the problem was that my client died.
Correct.
And the husband wanted to be a surviving spouse a few weeks after her death rather than an ex-husband for his benefit. If there are no further questions.
Thank you, counsel. Mountain Meadows Campers Association versus Campers Resorts, Inc.
Morning. May it please the court. Ann Campbell on behalf of Mountain Meadows Campers Association. The association asked the court to reverse the order of Supreme Court that held a couple things. First off, it held that 18 specific lots in the campground are exempt from assessments. We submit that the court erred in holding that as a matter of law. The amended declaration and the settlement agreement in the record provide the mechanism by which the association assesses every owner in the campground. Every lot is assessed, annual assessments that pay for property taxes.
Of course, you don't have that problem now. You don't have that problem now.
How is that?
At the end of 16, it only went till the year 16.
It did, Your Honor, but because that's one issue, but it may have further implications going forward because of the reasoning of the court. The court basically held that there's 17 lots that were formed by or are held by what are called M partnerships, and there's another lot that's held individually by one of the lot owners, Marie Tulamello. So the issue is whether those lots are obligated to pay assessments, which we claim, or are they exempt under the terms of the amended declaration and settlement agreement.
Does it bother you at all that there's only 5 lots involved here? Meaning, I know what's involved, but there's only 5 parties as such?
Yeah, there's only, the procedural history is a little complex, I guess I would say, because there's no doubt there's a long history here of litigation among the parties here.
What I'm thinking about is everybody's charted their course and everybody's fine with the fact that whatever we do affects the 18 lots and not just the 5 that seem to be parties here.
The issues would be similar, yes, Your Honor. I think that we can agree with that. That the issues that you're going to decide will have an effect on all the lots at issue. Yes, because of the limitations of the Lackawanna City Court, only 5 of those actions could be started at a time, and then the defendants removed those actions to Supreme Court, so we're really dealing specifically with 5 in this appeal. However, the implications go beyond that. So in any event, at Record 154, the provisions are that the owner of each campsite agrees to pay the association annual assessments and common charges of supplying water and electric sewerage. There are certain provisions in the documents that accept certain lots. That's true, we agree with that. One group of lots that are exempted are the personal lots belonging to Benedict Tulamello. We agree with that, that's not an issue. The next issue is there are also provisions in the agreements that Camper Resorts, Inc. lots for 2008 through 2016 are also exempt for those years. So the issue now is the defendants claim that the M partnership lots fall within this exemption. We say, no, they don't.
Well, the settlement agreement in paragraph 5, I'd like you to address that, where it says that it requires CRI to transfer its ownership and rights in the real property known as lots M-20 and M-21. How is that not indicating that they're the owners, and don't they then get the benefit?
Well, Your Honor, and that's precisely what Justice Niemoyer did point to. We submit that is not sufficient to prove that the M partnerships are to be treated like every other lot It is unfortunate, it's an ambiguous and unfortunate paragraph. However,
Unfortunate maybe for you, but maybe not
but
for your
yeah,
opponent.
true, but again, we submit that that's not compelling proof. It's one paragraph in a multi-page document. Again, only certain lots are intended to be accepted, and if you don't fall within those exceptions, the court went beyond its power, we submit, to hold that, to find other exemptions within the agreement that simply aren't there. So we already talked about the personal lots, but the CRI lots are just that. CRI was the developer. It's defined in the agreement as the developer. The Supreme Court conflated that with the M partnerships. The M partnerships were formed specifically to be a separate entity from CRI. There were issues about voting rights and voting powers, and the M partnerships were formed in 2008 or 2009, I believe it is. 1989, 20 years ago, to be specifically distinct from CRI lots. The CRI exemption also talks in terms of the fact that, yes, those lots are exempt, and any subsequent bulk purchaser of those lots are also exempt. The court, we submit, reached a strained interpretation of that provision by saying M partnership lots that were formed almost 20 years ago fall within this exception. How we submit it can't be a subsequent owner if that was 20 years ago. Also, it had to be a bulk purchaser, 5 or more lots. Each of these entities, each of these M partnerships is a separate entity. So therefore, again, we submit it does not fall within that bulk purchaser provision.
Is CRI in that partnership?
CRI is one of the partners. Only one, though. But there's also Benedict Tulamello, and there's also Diane Tulamello. It's a different entity than CRI.
But they're not out of all the way, CRI.
CRI is...
They're part of the M partnership.
They are one of the partners in the M partnership. Again, distinct entities, Your Honor, we submit. They were formed to be specific and distinct entities. They should be treated like distinct entities. And to your point, getting back to your point, Justice Whalen, at a minimum, we submit, the court went beyond its fact-finding or its authority to find as a matter of law. At a minimum, there's questions of fact. We submit there's enough here for the court to rule in our favor in any event, but secondarily and alternatively, the court should reverse the ruling against us as a matter of law. The other issue...
You should be wrapping up, counsel.
Okay, Your Honor. I'll rely on the brief then with regard to the amended declaration that talks about the fact that there's a provision that defendants relied upon in the amended declaration saying that lots which were owned by the developer and are not developed and not available for rental are also exempt. True, but again, developer is CRI, not the M partnerships. The final issue was there's a couple of other issues, but the utility charges, Your Honor, I'll rely on the brief. We submit that the utility charges are not supposed to be prorated. There's provisions in the agreement that clearly state that each lot pays for an equal share of the total utility charges.
Thank you, counsel.
Thank you.
May it please the court, Michael Ferdman on behalf of Camper Resorts. Just briefly, a couple of things with respect to your point, Justice Whalen. The logical, if you took their argument that the transfer of the M lots, the M20 and M21, are not indicative of what the intent of the parties was. Are they saying that that transfer has to be reversed? Because those lots were actually transferred. The settlement agreement says CRI transfers the lots M20 and M21. Their argument, brought to its logical conclusion, is CRI doesn't have control over M20 and M21 because they're separate and distinct entities. So our argument is, if they're right, then give us back lots M20 and M21 because that transfer is void. Another major point is Justice Niemeyer, as he points out, this has been going on for 25 years. Justice Niemeyer himself was involved in over a decade in the dispute between the two factions here. And finally, in 2008, there is a settlement agreement after 25 years of battle. Then 5.5 years later, they have a different lawyer and a different president of the board, and they decide to do this. And so I think it's clear that Justice Niemeyer understood that the parties had reached a conclusion to completely settle everything, and they, for whatever reason, decided that they wanted to start a new war. And he just wasn't hearing it, and that, I think, is the appropriate way to handle this. The rest of our arguments, I'm happy to rely on our brief. Thank you, Your Honor.
Thank you, Counsel. Zarnock versus Lakina.
Good morning, Your Honors. The facts are not difficult, and I've been before 4 different courts on this matter before, and I've asked for a dismissal of the affirmative defense on several or more venues. But what brings us here today, of course, is 2 minutes of time back those years ago when the father brought his boy over to see what was happening at the house they were going to build for the other son. And in those 2 minutes, I'm suggesting that under the law of the state of New York, there's no relinquishment, there's no transfer of control in those 2 minutes as the son stands next to his father, who was the general contractor.
And Counsel, your argument is it's as a matter of law.
As a matter.
In other words, this isn't a question that should go to a jury to determine.
Absolutely.
Because it's that clear.
It's that clear, Judge. And I would like to bring to your attention a case that I cited for the court, Zupan versus the Irwin. It's a Second Department case, and it's cited at 145 Appellate Division 3rd, 715. It was decided this past December 7th, 2016. And of course, this case just simply reminds us of the Murray case in the Court of Appeals, which talks about the relinquishment of the transfer of control from a general contractor to a special contractor. And this case also tells us again, as we well know the law, that the person who is going to become the special employee has to understand and has to consent. And I'm strongly suggest, by reason of what I've said in my brief, that there's no evidence, and there couldn't be any evidence, to suggest strongly in any way, or slightly in any way, rather than strongly, slightly in any way, that this young man who was terribly hurt is only entitled to his rights under the law of the state of New York with respect to workman's compensation. You cannot impose special employment under these circumstances in 2 minutes. Thank you very much.
Thank you, Counsel.
May it please the court. Well, the Zupan case is off point. In Zupan, there was no question about who the general contractor was, and in Zupan, the court, the First or Second Department, remanded for trial. So there was a question of fact.
Your opponent seems to be arguing that, look, this is such a brief, fleeting period of time, and where is there's nothing in the record that would indicate a shifting if you would, of the direction and control over this young man.
Right.
In this particular circumstances. So why don't you address that?
Your Honor, the temporal argument is clearly without merit. The leading Court of Appeals case, Thompson, says for whatever duration. The verdict sheet in this case said, was he the special employee at the time of the accident? Mr. Cosgrove's proposed request to charge said at the time of the accident, and Justice Siegel's charge said at the time of the accident, a charge that wasn't objected to. It's the quality of the relationship, not the duration, that counts. And here we had, it is true that it didn't take very long. They were lifting a wall, and the undisputed testimony is that my guy, Lucina, was the only one who spoke, told them when to start to lift, told them when to start it back down, and Mr. Jared Zarnock, the injured plaintiff, testified that he thought that Lucina was in charge. So during that period of time, I mean, the only work that there was lifting the wall, so the duration of it was confined by what the work was. And what the work was my guy was controlling the situation and giving the orders. I think that there are two other little bits of evidence that I'd like to draw to the court's attention. I think I mentioned them in my brief. But the bulk of the appellant's argument is that Zarnock Home Improvement was admittedly the general contractor, and that's clearly untrue. If I may just read 20 words from the record. This is the testimony of the plaintiff himself, Jared Zarnock. He testifies, this is a question, from the time that this house, the construction was commenced, up until August 6th, when this accident occurred, you had never been on that job site working? Answer, correct. So was Zarnock Home Improvement's actual work on that job limited to finish type work? Answer, it's mostly the type of work my father does. Question, so the answer is yes? Answer, yes. So his general employer was the finish contractor who had nothing to do on the day of the accident. And I think that the single most powerful proof in this regard is just one sentence more of the plaintiff's own testimony. We know from, it's undisputed that on the day of the accident, my guy's crew was doing the framing work. In the neighborhood, a few blocks away, Mr. Zarnock Sr. and his son Jared were building a shed on the father's property. They were called over to help lift the wall. And Zarnock the younger says, we were working at my father's house on the shed because we had some downtime between his jobs. That means that Zarnock Home Improvement didn't have any work to do that day. That means that the work that was being done was purely Lucina's work. The undisputed evidence in the record is that the owner of the house, Paul Zarnock, paid the excavating contractor, paid the mason, paid the HVAC contractor, and the home improvement company, the father's home improvement company, refused to sign the contract that my guy presented, under which he would have been the general contractor. So he also, Mr. Zarnock Sr. also testified that he had no control over the way the work was being done. So none of the characteristics of the general contractor did he have. He didn't supervise, he didn't pay the subcontractors, he didn't pay my guy. My guy testified without dispute that he was paid by the owner, Paul. And I just want to mention one other little thing relating to the reply brief. Some emphasis is made in the reply brief, not so much in the direct brief, about Judge Siegel's refusal to give a charge on the limiting the effect of the workers' compensation proof. Mr. Cosgrove was the one who offered that proof. Mr. Cosgrove was the only one who said anything about workers' compensation. And if you look at page, not only did Mr. Cosgrove, no, I'm not saying there's anything wrong about it, because he was trying to show that since the general contractor provided the workers' compensation, that was one indicia of the employment being still with the father and not with my guy. But Mr. Cosgrove specifically asked Judge Siegel to read a stipulation to the jury, which I agreed to, that said not only did the state insurance fund through the father's insurance provide coverage, but that the young Zarnock was receiving benefits through that insurance policy. I never made the argument to the jury, and had I done so, oh, you shouldn't let him get paid twice because he's already got comp. I didn't abuse that evidence. It was not offered with a limitation of effect. It was just offered by Mr. Cosgrove to prove what he wanted to prove, and it doesn't make any sense for him to then, during the charge conference 2 days later, to say, instruct the jury in some way to limit the effect of that proof. Thank you.
Thank you, counsel. Carr versus Sheehan.
Good morning, if it please the, I'm sorry, good afternoon. What we have here is an agreement to agree. The parties on the eve of trial in a non-jury case with Judge Sider in Oswego County came up with a basis of an agreement and ended up with a hand scratch on a survey, which is part of the record. The hand scratch was clearly subject to visiting the scene in better weather, which in Oswego takes a few more months, and seeing if the parties could agree. Clearly, Judge Sider said that in his recitation of the stipulation, is we need to come to an agreement. It wasn't that we have an agreement, it means we need to come to an agreement on that issue. And the parties went out to that scene, and my clients did not agree with how the surveyor was lining it up. Ultimately, the survey that becomes part of the record shows a perpendicular line. And that line, as described in the oral stipulation, is supposed to be as nearly to perpendicular. It doesn't say perpendicular. We may be talking about a small amount of distance that my clients were objecting to. They were reserving the right to move their boats and things. Respondents' counsel talks about...
That really seemed to be the key condition of the agreement, is that they would be able to, that the boundary, that they'd be able to draw around the boat and the trailer, right? That seemed to be
I agree that it does appear on the record that the boats and things, not necessarily a boat and trailer, which gets to the motion.
What I'm reading in the stip, I think it's a boat and trailer.
It does say that, and then it does say boat and things, and I'll point that out in the record for you. I just had it tabbed. It's on 25, and it reads, and that's why, this is Mr. Farrell, the attorney for the Sheehans. We need the surveyor out there. Is the Sheehans store boats and things on the parcel that they own? That's on the other side of Franklin Ave on the survey. So it was more than just a boat and a trailer to draw through. What's also not shown, I'm sorry, Justice.
It appears that your client's position they're taking is that this agreement was just so that, but they could disagree if they choose just to disagree. I mean, they don't seem to articulate, at least down below, and I looked at the arguments, they don't down below and say, well, you know what, we disagree with this line because these things we may have are 15 feet clearance or 12 feet clearance. It appears that they measured the trailer, they measured the boat, was I believe 8 feet or whatever it was. They came to 10 feet, and by looking at the agreement, and you call it an agreement to agree, obviously the court ruled otherwise. The question we look at it was it clear and unambiguous, the agreement that they had, and that's why you can hear the questions from my colleagues focusing on that agreement. How was that not clear and unambiguous that you wanted to move the boat and trailer?
Well, because the boat is one thing and then things are another, and things are certainly ambiguous.
Okay, now tell me where down below you have things in the record that you went to the court and says, Your Honor, it's just not the boat and things, just not the boat and trailer. We have other things being X, that therefore 10 feet is insufficient.
Yeah, my clients have expressed to me, not only is it the trailer, but other equipment and potential other uses. They also expressed that
Well, the other uses is not in the picture.
things, though, is because that's
I know, but
ambiguous.
I guess, kind of not getting on it, I mean, I'm trying to better understand this, because it appears to me that when you bring the application down below, it's not saying, Your Honor, don't enforce this agreement, because boat, trailer, we agree 10 feet's okay, but the things we put in there are X, Y, and Z, and those things happen to be 15 feet clearance, 20 feet clearance. And if I missed it, and I could have, I could be honest with you, where in the record do we have that from down below?
So, Your Honor, you're correct. The fact that the Sheehan's, in response to the motion to confirm the order, did not reply and say specifically, these are the problems that we have. What they relied on was Judge Sider saying, we have an agreement. If you agree, when you go out there, once you meet with the surveyor, if you agree with that line. If you don't, we're adjourning this trial and we'll come right back and we'll try the case.
So the argument here is not the things in the agreement. The argument is, as I stated earlier, your clients were under the impression that if they did not agree with the line of the surveyor, they could just reject it.
Well, I agree that,
with no rationale to it.
if I may, I think that it's a combination of the two. They relied on the judge, and that was the problem, is that the judge says if you don't agree, whether it's arbitrarily or not, if you don't agree, and I submit that, as the court has ruled in other cases, it has to be with some substance. It can't be arbitrary. It can't be on a just we don't feel like it. It can't be that basis. When they got out there and they visualized it, they're in a courtroom, they're drawing a hand-drawn line. When they visualized it, that was the key to see if that line that they visualized was going to be adequate to move the things, including the boats, that they needed along that line.
So really, this case really boils down to something I wouldn't call simple, but relatively narrow. It's our interpretation, ultimately, of what the contract, what the agreement on the record in the court said, and whether or not that's an enforcement.
I would agree, and that's the basis this court has ruled in other cases, including the Walker case that I note that three of you sat and participated on, and with Judge Sider and Oswego County and Alandria. What was the agreement? Was it unambiguous or was it ambiguous? And in that case, the court did send it back for a hearing on that basis, and I would submit to you that at least there should be a hearing on the issue of what are the things and what was the intent of the parties, and that it's not clear on the record here that it was as simple as the surveyor drawing a perpendicular line and the judge saying, that's it.
Thank you, counsel.
Thank you.
Good afternoon, and may it please the court. David Gertzen on behalf of the respondents in this case. I think it is clear that we disagree with the appellants on the key issue, which is whether the agreement was specific enough to enforce. And Judge Sider, we believe, correctly found that it was specific enough to enforce. If the contention of the appellant is accepted, then there was no reason to put any details on the record concerning a perpendicular line with Lakeshore Drive, a survey point that was established from the survey that was before the court during the 2-hour negotiations of the settlement agreement on the day of trial. We didn't agree to try this having witnesses, a surveyor witness lined up for the first day of trial, witnesses from Pennsylvania lined up for the first day of trial, parties from out of town on the first day of trial, simply to come back when the snow was off and maybe redo the whole thing again. We were ready to go. We spent 2 hours settling the case. The defendant's counsel at the time, Mr. Farrell, put on the record himself what the parameters of the settlement were. We broke it down into who was going to pay for what. And importantly, he also went on to say that we want to be able to draw any boat and trailer from their camp, which is across the paper street to the garage lot. That is a significant detail. And I would just point out that anything that can legally be drawn across the road without a special permit is no wider than 8 feet in New York State. The court can take notice of that. We measured their trailer. It doesn't matter if you're hauling a backhoe down the road or you're hauling a boat. You need a special permit to haul something wider than 8 feet. They have a couple feet extra. There's a building on one side that's their building. The parties in their settlement agreement and the deed that the judge ordered them to give stipulated that the little piece of land north of the agreed upon boundary would not have buildings on it. Our people are only going to use it to store equipment, which they've done with the entire lot for a long period of time, the basis of the underlying claim. So, we think that the judge arrived at the correct decision here. And I will note that one of the reasons they did need to go out and survey after the fact, 2 months after the trial date, is that the garage was not on. You'll note in the record at page 33, the garage on the defendant's land was not on the first survey. They had a pretty good idea there was room enough to get a boat and trailer through there. But we needed to locate that building. They did that, went back to the court. They didn't put anything in the record in that motion to Judge Sider, which explained why they needed more room. They just wanted a bunch more room, and they wanted to take about a third of the land that they had agreed to give to us in the settlement.
Thank you, counsel.
Thank you.
Pierce versus State of New York.
May it please the court, my name is Michael Higgins from Mental Hygiene Legal Service. I represent Leroy P. I'd like to address the sufficiency argument. We assert that the state did not present sufficient evidence for two reasons. One, that they didn't present sufficient evidence that my client is currently a dangerous sex offender requiring confinement, nor did they present sufficient evidence to adequately distinguish between a dangerous sex offender requiring confinement and a...
Now, Dr. Tope had the ability to take a look at not only had the report from the previous evaluation, but took a look at records leading up to the time of this appearance. Isn't that right?
That's correct.
And so why is that your argument that Dr. Tope wasn't, her evaluation wasn't current?
No, we don't argue that she didn't make a current evaluation. She clearly reviewed the record, she looked at different factors, but she delineated what was important to her, and when she delineates what was important to her in that evaluation, none of those factors are present factors. They're historical factors. She says in the record on pages 79 to 80, she summarizes the reasons that she believes that Leroy P. Is currently a dangerous sex offender requiring confinement. She lists 4 reasons: that he has a long history of offending. That's the facts of his offense. Donald D.D. and the Kenneth T. portion of Donald D.D. says that alone is not enough. She also points to offending after sanctions. That again is another factor identified in Kenneth T. As insufficient. Then she says that he possessed pornography in the community in 2014. Well, that's plainly a false fact. That's not something she can rely on because my client's been confined since 2010. That's clear in the record. She may have mistakenly been referring to his 2004 parole violation, but if that's the case, then again, we're talking about a historical fact that would fall under the Kenneth T. portion of Donald D.D. The only arguably sufficient current evidence of whether or not he's a dangerous sex offender requiring confinement is that she says that he has not comprehensively discussed his past behavior in treatment. So,
well, she was a little more specific than that, wasn't she? She said that with respect to his treatment, he has focused only on his teenage victims, not on his child victims, and that was of concern to her.
She does say that. I don't know that that's borne out by the record. First, that's not his goals within treatment.
Well, weren't his goals modified so that would be part of his goal to address all of his victims?
Well, Dr. Tope says that she does not take that into account. She does not take the modification into account in her evaluation. She disregards the final individualized service plan. So she sets that aside, and I don't think that we can take that into account in determining whether or not her evaluation has a sufficient basis. You know, we can't just look to the mere fact that she looked at the records. We have to look behind her evaluation. And also, I don't think that her evaluation sufficiently distinguishes between dangerous sex offender requiring confinement and one who could be on cyst. And that's because in Michael M., the Court of Appeals tells us that if you have some ability to control, then you're not a dangerous sex offender requiring confinement. Michael M. says that a dangerous sex offender requiring confinement has an inability, which it says is a near complete inability. And Dr. Tope recognizes that my client has some skills to prevent his sex offending cycle. If you have some skills, you have some ability to control your offending behavior. So I think for that reason, they're not sufficiently distinguishing.
Didn't even the petitioner's expert testify that the petitioner was still a moderate to high risk to reoffend?
He did, and I think that that is instructive of the difficulty of distinguishing someone who has a mental abnormality from someone who's a dangerous sex offender requiring confinement. We're talking about the difference between serious difficulty controlling your sex offending behavior and an inability to control, or such an inability to control your sex offending behavior. That's a gradation, right? Article 10 is trying to define three separate classes of people. People who don't have a mental abnormality but have still committed a sex offense. They don't need civil management, right? My client admits, or consented to a finding, rather, that he does require civil management, right? So he has a serious difficulty controlling his behavior, just like Michael M., who was out in the community, who was having difficulty with sexual urges, but was not acting on those sexual urges. So everyone we talked about is gonna have some level of difficulty controlling their sexual behavior. We're talking about what's the difference between
Whether they require confinement or not. That's right?
Well, I think that summarizing
And how do we determine that?
Right, but I think summarizing it in that way, just the choice between cyst and confinement, shifts the burden back to my client. The burden is on the state to prove that you're currently a sex offender requiring confinement. So it's not just a choice of once you require confinement, now you continue to require confinement. We have the passage of time, we have intervening treatment, and we have the burden on the state. You can imagine a system where my client has to come back and say, no, I'm no longer a dangerous sex offender requiring confinement. That's not the system that we have. And so I think that framing it in the way of just choosing between cyst or confinement makes those equal choices. They're not equal choices, they're unequal choices.
Well, I guess I frame it that way because your claim here on appeal is that there's insufficient evidence to establish that he requires confinement.
That's correct. That is our argument, and I suppose I'll rely on the brief for the remaining arguments if there are no other questions from the court.
Thank you, Counsel.
Thank you.
Good afternoon, Your Honors. It is a difficult decision, but that was a difficult decision made by the trial court. The trial court was in the best position to evaluate the experts' opinions and to evaluate their written reports and to decide which opinions were more credible than others. In this, I don't want to. This is a very factually intense case. Obviously, I don't want to rehash each fact. I would like to point out some of the highlights of the Dr. Tope's opinion. As was already pointed out by Justice Peredato, really what makes, the primary thing that makes Leroy Pierce dangerous is his superficial engagement in treatment and his failure to deal with the full scope of his sexual offending conduct. In treatment, he has talked about the crimes that he's committed against 12-year-olds and 14-year-olds, but he hasn't talked about the crimes that he's committed against 7-year-olds, nor has he talked about the fact that he has also committed, the 12 and 14-year-olds were known to him, but one of the 7-year-olds was not known to him.
And Counsel, your argument there is that that's displaying some type of a lack of awareness of his problem and therefore an inability to manage it? Is that the argument?
Exactly. That goes to the core. If he doesn't really understand his own sex offending cycle, or he's not fully addressing that cycle, then it's impossible for him to form an adequate relapse prevention plan that would make him a safe bet in the community.
And those indicate the failure to do that, the failure to address those things are in current records, meaning that that's currently taken.
That's a current determination, and I think that's really the core of what makes Leroy Pierce particularly dangerous. Yes, there is historical information about the amount of the crimes and the nature of his pedophilic disorder, which is a chronic lifelong condition. Yes, those are all also important. But to me, the failure to address the number of crimes, sex crimes, and his failure to address the full scope of his sex offending conduct, that's what makes him a dangerous sex offender.
So are we in a place, though, where had he, during those counseling sessions, addressed those issues, that change, are we now in a place where he doesn't need confinement and cyst would be appropriate?
I don't think so.
Is it that simple?
No, because there are many other factors which have been cited here, having to do with actuarial risk assessments and the dynamic risk factors that go into his particular, this gentleman really has no ties to the community at all, no family ties. He has apparently substituted, the record would indicate that he has sought out relationships with young females to substitute for adult relationships. There's a myriad of other factors that go into this. I'm just trying to highlight for the court what I think are the most important ones. It's because there are so many factors and there isn't a litmus test per se that it's particularly appropriate to give deference to the findings of the trial court in a case like this where it's so factually intense. Unless the court has any other questions, I'm prepared to rest on my brief.
Thank you, counsel. Ferris versus Mercier.
Good afternoon, Your Honors. May it please the court, Michael Ostrander for respondents, estate of George Mercer and GMC Management. It appears that my opponent is submitting. Justice Rosenbaum gave very thoughtful and thorough treatment to his decision. We have an expanded discussion of it with citations to the record and additional authorities in our brief. Unless the court has any questions, I'm prepared to rest on our brief.
Thank you, counsel.
Thank you, Your Honors.
Bethlehem Steel Corporation versus County of Erie.
And then there was one, Your Honors. Good afternoon, may it please the court. My name is Craig Leslie from Phillips Lytle on behalf of the petitioners here. With respect to the parcel benefit charge at issue, the Erie County Sewer District Number 6 made a determination that they were going to follow the edict of County Law Section 271. When they did that, when they made those resolutions, repeated resolutions, that was how they were going to fix these parcel benefit charges, they obligated themselves to assess, as nearly as may be, the benefit to each parcel within the district and to use that as the basis for assessing these parcel benefit charges. It's in their resolutions, it's in the statute. That's not what they did. They didn't look at the factors that are outlined in the cases that we've discussed, Clark, Elwood, and Clock, all of which remain good law, and I'll explain why in just a minute. They didn't look at the effect on market value from having access to the sewer. They didn't look at the development possibilities from having access to the sewer. They didn't look at the particular characteristics of the parcels within the sewer district to determine what benefit each one was receiving or what each class of property was receiving. They didn't consider zoning or use of the property. What they did, and what Mr. Alessi did, who was the architect of this parcel benefit charge formula, was he looked at some residential developments outside the city of Lackawanna, concluded that in any of those developments, approximately 60% of the total acreage was available for residential development for actually building on. Took that 60%, applied it to a 1 acre parcel, said, okay, if there's a 1 acre parcel in the city, about 60% of it can be developed. The lot size or average lot size in the city of Lackawanna is about 4,800 square feet, thereabouts. Therefore, you could put 5 residences on each acre. Therefore, for commercial properties, but only commercial properties exceeding 1 acre, I'm going to have a 5 times multiplier for the parcel benefit charge. So if you're a residential property, you have 1, 2, or 3 family residents on the property, you get 1 parcel charge. If you're a commercial property of 1 acre or less, you get 1 partial charge. If you're a commercial property of more than 1 acre, you get 5 times that 1 parcel charge. And the one thing that is lacking in this record, and I submit to the court is the critical factor in this case, is there is no analysis of how a commercial or industrial property that's larger than 1 acre gets 5 times the benefit per acre from the sewer than does a commercial property of only 1 acre or a residential property of only 1 acre. It's 5 times the benefit is what is essentially being asserted here by the sewer district.
Now, the benefit can both be benefit, like present benefit, and also future benefit, correct?
They can certainly consider future benefit.
So future development
Your Honor.
of the parcel
Correct.
could result in a benefit to the owner.
Correct. And if there was a factual analysis of that, this would be a different case. There is no factual analysis of that. And we've referenced in our briefs the Dorfman case, which Judge Whalen, Judge Perodato, and Judge Scudder, you sat on last year, where the City of Salamanca Water District decided we're going to increase double the charge for property owners that have a meter of 1 inch or greater. We're going to double that charge. And what you heard from Mr. Spitzer in that case was, well, it's fair to assume if you have a larger meter, you're going to use more water, and therefore we should be able to double that charge. And what this court said was, well, where's the factual basis for that? Fair enough, if that is true, if you can establish that factually, that you had a factual basis to do that. But where's the factual basis? It's the same thing here. What you see in the briefs from our opponent is the idea that a larger parcel, you can assume there's more benefit. Well, where's the factual backup? Where's the factual analysis that was done to determine that there is, in fact, a greater benefit, much less a 5 times greater benefit per acre? So you would have, for example, 1,000 commercial properties within the city, each of 1 acre. You would have a total of 1,000 parcel benefit charges. However, our property, approximately 957 acres, you end up with 4,785 parcel charges, almost 5 times as many. Where is the justification and the analysis factually that that benefit is so much greater for a property that is larger? We submit to you it's not in this record, and in fact, Mr. Leslie admits they didn't do any such study or analysis.
Okay, I think we have that argument, Counsel.
Okay. With respect to, very briefly, the affirmative defenses that were raised, I'd like to say just a couple of words about those. I think we've addressed them thoroughly in our brief, but clearly there was a lag in time for most of these defenses where the city decided not to raise them, where the city decided to rest on their laurels and essentially try to lay a trap for the unwary is the best way I can think about it. Because if they had said, for example, you have voluntarily paid these amounts, and they had asserted that defense at the outset, then we would have done something differently. Not that it's required, and we submit it isn't required because of the history from 2002 through all years except 2007, where there have been consistent and repeated challenges to this. We've demonstrated the authentic resistance that the Court of Appeals requires. But again, we would have changed our behavior. To the extent that they rely upon a stipulation of settlement involving only one of the petitioners from 1 year in 1997, and allege essentially that continued in perpetuity. Clearly that's not within the ambit of that agreement. If you look at it, it says it'll have a 5-year term, it'll continue year to year. It doesn't contain an express provision with respect to repudiating that agreement or discontinuing it, but it didn't need to. It was repudiated when we filed the first of these many proceedings years ago and continued to file them thereafter. And in addition, can't be res judicata effect because there was no dismissal with prejudice, and because these are charges that are calculated annually, anew. Each year, the sewer district is supposed to calculate these and supposed to publish and give an opportunity to be heard. So it's not an agreement that in perpetuity would apply or would bind the other parties here. And then last but not least, the exhaustion of administrative remedies. I think, again, first of all, you have the constitutional challenges here. I didn't address those in great detail at first, but when we talk about an arbitrary or palpably arbitrary basis, we talk about treating a property owner differently from others within the district without a rational basis for doing so or a rational relationship of that 5 times benefit to this parcel. You have a constitutional challenge. We've asserted that constitutional challenge. That is an exception to the exhaustion of administrative remedies requirement. And of course, they didn't even publish the correct notices advising the taxpayers or the charge payers within the district that they had the opportunity to object and that the meetings that were being held would in fact hear and consider objections. They just said there's going to be a public hearing about the roll. That's not what county law section 271 requires. And again, didn't assert that until later on. So that's it.
Thank you, Counsel.
Thank you.
Thank you, Your Honors. Dan Spitzer on behalf of the county, not the city this time, the county. In terms of this, what we're here is hearing a case from an owner of a property that equals, at the time for most of these cases, 1/4 of the city complaining about an assessment that equaled 9% of the total revenue and being told it's unfair. And when the city went into bankruptcy and the state stepped in and asked the county to create the new district, and the county did choose to take that on, at that time, Bethlehem Steel was paying a user charge and an assessed value charge. Because of exempt properties in the city, they were paying about 60 to 70% of the entire sewer charge. Now we're hearing complaints about an assessment valuation, a different formula that has reduced this to less than 10%. What Mr. Leslie forgets to mention to this court is that there are 2 charges under 271 that are assessed as part of a 4-part formula to calculate all the values that are derived, potential and actual, to all properties. Those values include an assessed valuation charge. Now, this court is well aware that that assessed valuation of that property has changed. In fact, you upheld a settlement where the property value was set at 0 because of contamination. Obviously, when an assessed value is properly set at 0 because of contamination, that's not reflecting at all any value to the benefit, which the record clearly shows has the largest sewer pipe in the county. 2.25 million gallons a day can be served through that property. And indeed, the renaissance of that property, which Mr. Leslie and his law firm and his client have had a lot to do with the things coming back, the new industrial park that's just been announced, utilizes those sewer agreements, and that's all in the record. It's interesting listening to Dorfman. It's a case that seems like lately when I'm in front of you, it's cases where I've been called to the case late and perhaps should have been called earlier, like when the record was created. I do like part of Dorfman, especially the part where there were no refunds for reasons that we'll get into. But there's a huge difference between Dorfman. I stood in front of you in Dorfman with basically 3 pages of minutes, not 30 years worth of an expert attorneys. Let's not forget something very important here. The burden of proof is on the petitioner to show that the methodology is unfair, and you have no such proof. You have a few attorneys' affidavits. You have a 4-page affidavit from one of the finest remediation engineers in the country who knows nothing about sewer engineering or setting up districts. And you have 2 experts, Mr. Alessi and Mr. Fiegel, who have talked to you exactly how they figured out the 5 per acre, why it was fair, and how they did it, with no objection of an evidentiary nature. At that point, you really should be done, because there's no evidence showing that it was unfair. It was a fair way. There's 4. They took 266, 270, and 271, and they split it up fairly. If there's no other questions on that portion, I'll move to the affirmative defenses. We would respectfully submit that the court below correctly added those defenses because of the timing when they arose. As we showed in the record, we did not learn of confirmation that no payments had been made under protest until August, late August, and we made the motion to amend within 2 to 3 weeks. It was timely. It was close to the eve of trial, because there was no trial because we got summary judgment, but it was certainly timely in terms of when it was discovered. Moreover, the idea that a leading law firm and a leading plaintiff who's had lots of tax cases didn't show up at 26 public hearings over 13 years and then argues that it didn't know. The public hearing notices certainly work. They have the language that's required. Everyone wishing to be heard shall be heard. Pro and con. There's nothing missing from that language. There's no case law that they can show that shows that those...
Does the fact that they brought litigation annually from 2002 change this analysis?
In my opinion, I think the cases say no. They cite the Ciccarelli, and I may not have pronounced that correct, but Ciccarelli actually pointed to was a case where they had brought to challenge an assessment before the taxes were paid. The Court of Appeals, in its cases that we cite in our brief, has held otherwise and said no. And Ciccarelli itself is very instructive, because it was the Hurd case, where for years people knew the assessments, all over the state people knew the assessments were illegal and the whole system had been thrown out. And the court said, that's not good enough, that's not active resistance, that's not showing resistance, merely filing cases. So I think if you look at the cases that are cited by both parties, while I would certainly concede it's not an absolute clear line, the courts have very much said that you still have to show payment, and just filing cases is not enough. The exhaustion of remedies, I think I've covered in terms of there were notices, they did not exhaust, and constitutional claims, just to finish on that point, when the factual record is required, then the exception to exhaustion of remedies for constitutional claims does not apply. The Court of Appeals put a sword through that argument in the Oyster Bay case. Does the court have any further questions for me?
Thank you,
Not, the day's late. Thank you for your time. I've got a really bad cold, so I'm not going to share it with you, Craig.
I appreciate that.
No problem. Tim Hoover says hi.
Please give him my best.
I will. I was in last night printing off cases, and he goes, I see you going up against Craig. Tell him it's